Thank you all. We are, having spoken to the three children and given them short oral reasons for our decision and the decisions themselves, we are now handing a full written judgment down, and we are accompanying that full written judgment with a written press summary, which is available to everybody. The neutral case citation number is 2026 EWCA Crim 845. The judgment will be put on the National Archives in the normal way. We propose to give a short oral summary of that judgment now. We remind everybody of the reporting restrictions which are in place. This was a difficult sentencing exercise, given the number and seriousness of the offences, but also the ages and vulnerabilities of very young children. The judge carried out a careful sentencing exercise in accordance with the statutory principles and the sentencing guidelines that he was required to follow. However, we decided that the non-custodial sentences which were imposed by the judge on X and Y were unduly lenient. X was convicted of an offence of rape committed against C1 in a first incident, and a further offence of rape against C2 in a second incident. Y was convicted of 3 offences of rape against each complainant in each incident, 6 rapes in all. Both X and Y were also to be sentenced for their part in filming these offences. Each incident involving rape by more than one offender was extremely serious, but the fact that they repeated their behaviour after the first incident and did it again to a different person in the second incident is the crucial feature of these cases. It rendered a significant sentence of detention for X and Y unavoidable. Z, on the other hand, was involved only in the second incident and was convicted of 1 offence of rape by encouraging Y to commit the offence against C2. He is younger than X and Y, and in his case, the judge's sentence was not unduly lenient, and the Attorney General's application in his case has been dismissed. We're going to give a quick summary of the facts and the reasons. Following a 29-day trial in the Crown Court at Southampton, the 3 offenders, X, Y and Z, were convicted of rape and other sexual offending that had taken place in Fordingbridge, Hampshire, against 2 separate complainants, C1 and C2, on 2 separate occasions. The first incident occurred on the 26th of November 2024 and involved X and Y only. The second incident occurred on the 17th of January 2025 and involved all 3 offenders. Each offender had pleaded guilty shortly before trial to offences of taking indecent photographs of a child. X and Y were both aged 14 at the date of the first and second incidents and 15 at the date of conviction and sentence. Z was 13 at the date of the second incident and 14 at the date of conviction and sentence. The complainants were also young. C1, the complainant in the first incident, was 15 years old at the relevant time. C2, the complainant in the second incident, was 14 years old. We have set out the circumstances in which the offending took place and the details of the individual offences in paragraphs 20 to 41 of our written judgment, and reference should be made to those paragraphs. We also set out specific findings made by the judge at paragraphs 75 and 76 of our written judgment. The offenders were sentenced on the 21st of May 2026 by the trial judge. In respect of X and Y, he passed a youth rehabilitation order with intensive supervision and surveillance programme for a period of 3 years. In respect of Z, he made a youth rehabilitation order for 18 months. The requirements attached to each included supervision, a curfew, and compliance with specialist harmful sexual behaviour intervention. The Attorney General sought, and we granted him leave, to refer the sentences to the Court of Appeal Criminal Division under Section 36 of the Criminal Justice Act 1988 on the ground that the sentences were unduly lenient and ought to be increased. It was argued that the extent and nature of the offending was so serious that non-custodial sentences could not be justified, and that sentences of detention should have been imposed on each child. In particular, it was argued that the judge had wrongly assessed the level of harm caused to the two complainants, and, in respect of X and Y, had had insufficient regard to the number of offences and the fact that they had repeated their offending behaviour. In response, it was argued on behalf of each child that the judge who had heard the facts at trial was best placed to make decisions about the level of harm caused and the seriousness of the offences. Reliance was placed on the very young ages of each of the offenders, their own vulnerabilities, and their prospect for rehabilitation. The court was reminded that custody for a child is a sentence of last resort, and that the court is required to take an individualistic and child-centred approach in order to fulfil the statutory requirements, to have regard to the principal aim of the youth justice system, which is to prevent offending or reoffending by a child, and to have regard to the welfare of the child. Any judge passing sentence, and this court on appeal, must apply the statutory framework enacted by Parliament as contained in the Sentencing Act 2020. Section 230 of the Act states that a court must not pass a custodial sentence unless the offence is so serious that no other sentence can be justified. In forming that opinion, the court must take into account all the information that is available to it about the circumstances of the offences and any aggravating or mitigating factors. Section 63 of the Act sets out that the assessment of seriousness is to be made by considering the offender's culpability in committing the offence and any harm which the offence caused, was intended to cause, or might foreseeably have caused. In order to make these assessments, courts are required by Section 60 of the Sentencing Act 2020 to follow all relevant sentencing guidelines. Where the offender is a child under 18, these include the overarching guideline, sentencing children and young people. We call this the principal guideline, and any offence-specific guideline applicable to children. Here, the Sexual Offences Sentencing Children and Young People guideline. These guidelines, read together, require the sentencing judge to follow a stepped approach to assess the seriousness of the relevant offences in context and to determine whether the offence passes the custody threshold. Having done so, even where the court concludes that the custody threshold has been passed, the court is required to review the sentence and to consider the full range of sentencing options. So the fact that the circumstances of the offence are such that it passes the custody threshold does not mean that a custodial sentence is unavoidable. Where the offender is under 18, the court must comply with the statutory provisions set out in Section 37 of the Crime and Disorder Act 1998 and Section 44 of the Children and Young Persons Act 1933, which together require every judge dealing with a child offender, 1, to have regard to the principal aim of the youth justice system, which is to prevent offending or reoffending by a child, and 2, to have regard to the welfare of the child. Sentences for children must therefore be individualistic and rehabilitative where possible. By law, custodial sentences must only be imposed as a measure of last resort and where an offence is so serious that neither a fine alone nor a community sentence can be justified. If a custodial sentence is imposed upon a child, the court must state its reasons for being satisfied that the offence is so serious that no other sanction would be appropriate. The judge's assessment of seriousness was the issue at the heart of this appeal. As we've already said, this was a difficult sentencing exercise, given the number and seriousness of the offences, but also the ages and vulnerabilities of very young children. The judge did carry out a careful sentencing exercise in accordance with statutory principles and the sentencing guidelines that were relevant. He made findings of fact that were relevant to the sentencing exercise, in particular that both C1 and C2 had had consensual activity with at least one of the offenders prior to the offences taking place, that the offences were not pre-planned, and, in respect of Incident 2, that no knife had been used and C2 had not been forced to give up her phone to avoid being tracked. As the trial judge who had heard the evidence, he was entitled to reach those findings, and he was best placed to do so. In respect of X and Y, the judge was satisfied that their offending passed the custody threshold, but bearing in mind their ages, vulnerabilities, and the time spent in detention prior to trial, he concluded that it was possible to step back from imposing a sentence of detention. In respect of Z, 13 at the date of convictions, and whose role had been limited, the judge concluded that his offending fell short of the custodial threshold. On review, we carried out a detailed analysis of the relevant statutory provisions and the sentencing guidelines. We considered and we took into account a significant amount of information about the circumstances of the offending, the vulnerabilities, and the levels of culpabilities of the offenders. And we took into account the effects that the offending had had upon the complainants, as detailed in their victim personal statements and the harmed person reports. We also received lengthy submissions, in writing in particular, as well as orally, from all the parties. And after we had assessed all this material in the context of the statutory framework, we concluded that the judge had erred in his assessment of the seriousness of the offences. In particular, we found that he had failed to take sufficiently into account the ages and vulnerabilities of the complainants and the psychological effect upon them, which we considered to be severe. The humiliation and the degradation resulting from the filming and the group offending, the number of individual offences, and in respect of X and Y, the fact that there were 2 separate incidents. We found that for each child, the offences passed the custody threshold. But insofar as Z was concerned, although his offending passed the custody threshold, we have found that a custodial sentence was not unavoidable. He was only 13 at the time. He was only involved in the second incident. His role was limited to assisting or encouraging another to carry out rape, and he did not himself take part as a principal. We found that it was reasonable to approach his case on the basis that he had joined a group, X and Y, which had committed the offences in the first incident and was seeking to repeat that behaviour. So we have declined to review the sentence imposed on Z, which we considered to have been a proper sentence and not unduly lenient. But insofar as X and Y were concerned, we reached a different conclusion. Their involvement in the 2 incidents, taken together, was such that an immediate and substantial sentence of detention was required. X and Y participated, either as principals or as assisters or encouragers, in multiple rapes carried out in front of others, and in which the complainants were subjected to humiliation and degradation, in particular by the filming of the offences as they took place. We found that the judge had undervalued the seriousness of their offending and the serious harm caused by it to the complainants. Notwithstanding their young ages and their vulnerabilities, sentences of detention for X and Y were unavoidable. We stated that, had X and Y been adults, Custodial sentences substantially in excess of 10 years would have resulted. We reduced the sentences that would have been passed in those circumstances to take account of the mitigation available for each child, time spent before trial, either in detention or subject to stringent bail conditions, their lack of previous convictions, and their vulnerabilities, about which we were provided with substantial expert evidence, and which, particularly in respect of Y, significantly reduced his level of culpability. We then followed the principal guideline, which suggests that where the child is under 15, it may be appropriate to pass a sentence that is less than half that which would be imposed upon an adult. We quashed the sentences imposed on X and Y in the Crown Court and imposed on each of them sentences of 4 years detention under Section 250 of the Sentencing Act 2020 on each count of rape to run concurrently. We also quashed the 10-year restraining orders on X and Y and replaced them with indefinite restraining orders. We have declined to find that either X or Y was a dangerous offender under Section 308 of the Sentencing Act 2020, such that an extended sentence was necessary. The young age of both boys meant that there was a real prospect of development, maturity and rehabilitation. Finally and separately, we have made some comments about the administration of justice more generally. We have expressed our concern about the inaccurate reporting and the misinformed and inappropriate commentary by members of Parliament, the media and elsewhere that have preceded this review and whilst legal proceedings were ongoing. We have been particularly critical of the conduct of the Crown Prosecution Service, which published a formal press release following the sentencing hearing, which it knew, or should have known, was neither a fair or accurate representation of the factual basis for sentence. It was this inaccurate press release that appeared to be the root of the misconceptions that followed, in particular, the misconception that this offending involved a knife-point rape and that C2 had been forced to give up her phone to avoid tracking. These mistakes portrayed the offending as even more serious than it already was. It took almost 3 weeks for the Crown Prosecution Service to correct the relevant inaccuracies. Can I ask the court staff, please, now to distribute the press summary and also written versions of the full judgment. When you receive that document, Mr. Little, you will see that we await the explanation from the DPP. We would like that explanation by 4 p.m. next Thursday, please. That is the 9th of July. You will all see from the written judgment that we will decide then what, if any, further steps are necessary. You will also see that our concern is not limited to the inaccuracy of the press release, but the inaccuracy of wider reporting generally and the absence of any corrections to that reporting. We would invite the parties, you will see the judgment is very long, but nevertheless, if you can please, to agree editorial corrections by 10 o'clock next Tuesday. If when you see the judgment you are unable to meet that deadline, please do get in touch with us. But if you can meet the deadline of 10 o'clock on Tuesday, that would be extremely helpful. There may be points of detail in the drafting of any order that I hope we can deal with outside the confines of a formal court hearing. We will retire now and be available for any questions or queries to be relayed to us. But Ms Wade, Mr Henry, are there any points that immediately spring to mind that you would like to raise with us?
No, thank you, Melody.
Lady, with great deference, because obviously it's probably included in your the court's written judgment, but I did not hear the time spent actually performing the order.
It's all taken into account.
I'm very grateful.
No, thank you for raising that. Ms Ayling? No, thank you. Mr Little?
No, thank you.
We have also, for the benefit of Sky and others, produced as it were, a clean version of the oral notes that I gave, of what I said to the boys. There are copies of the notes that should go to the boys with names on for you to give to the boys so that they've got something to look at and read with support when it's all calmed down a bit for them.
Thank you.
Thank you. This has been a difficult, sensitive matter for everybody. Can I thank everybody in court for their courtesy and their patience? Can I express particular thanks to all counsel in both rows for the assistance and powerful advocacy and helpful submissions that we have received. If there are any other matters with which we can help or assist the parties at this stage, or if we are needed to support any arrangements that are being made, please don't hesitate to get in touch with us. As you will see from our judgment, it may be that we have to have a further hearing on discrete issues that are not related to the merits in any way of the outcome of the actual substantive references. But if we have to have a further hearing to deal with consequential ancillary matters, then we will see each other again then. For now, thank you all. Thank you to the court staff for the careful arrangements, and we will rise.
All rise, table. Thank you, my ladies and my lord. As you know, I appear on behalf of His Majesty's Attorney General. To a certain extent, you've already introduced leading counsel, my lady, in terms of X, Y, and Z.
Yes.
So the juniors, very important, of course, Mr. Evans, Miss Sheffy, and Miss Fowler Rolt are the juniors for X, Y, and Z.
Yes.
As the court is well aware, these applications relate to sentences passed on the 21st of May, 2026. And then an application to refer those sentences within one working day because of the bank holiday weekend, and then this court expediting the applications, which we asked to be done, but I know that a significant amount of work has been done, so thank you to the court administration as far as that's concerned. The only reason I raise that is that I will touch on that at the end of my submissions in relation to points that are made about double jeopardy in the context of such an expeditious decision having been made in this case. The facts are set out in the usual way in the final reference, and I'm not going to at this stage address them, but will, during the course of my submissions, refer to certain relevant factual matters. But at the outset, can I hope, make four matters abundantly clear. First, this was, we accept, a difficult sentencing exercise in light of the ages of the offenders, the ages of the victims, and the verdicts, and for a number of other reasons. But at its heart, it involved the application of well-established principles set out in statutory provisions, relevant sentencing council guidelines, and in the principal authorities. Second, and allied to that point that I've just made, I am not seeking to ask this court to depart from any statutory provision, any guideline, or any of the principal authorities, but instead to apply them properly. Our point about the absence of a need for extensive jurisprudential analysis, as set out in the final reference, appears to have been misunderstood by the offenders. We have not said there is no need for any jurisprudential analysis. We have not eschewed consideration of the principal authorities. We refer to ZA, for example. Our point is that on these facts, there was no need, and there is no need, to consider fact-specific sentencing authorities from this court. And indeed, although the judge referred to a large number of them, he made exactly the same point. And on that matter, we agree with him. This court is generally not assisted by fact-specific, unreported authorities, and this case is no different. So the use of the adjective extensive was deliberate on my part, and I still maintain that submission. Third, the court will of course regard this judge as being well placed to make the assessments that he had to make. He presided over the trial, and he had managed the case in advance of that. However, you have been provided with the recordings that do exist of some of the offending, the CCTV, the transcripts of the evidence of C1 and C2, as well as the evidence that they gave in chief in terms of the recordings. But you are self-evidently not in the same position as a trial judge, and I don't begin to suggest you are, but you are in as good a position as you can be to assess the criticisms that we do make of some of the assessments and conclusions of the judge. Fourth and lastly, in this general introduction, we accepted in the final reference that the judge did try to apply the relevant principles, but our submission is that he misapplied them and made a number of errors along the way, the cumulative effect of which was to lead to unduly lenient sentences. And as you know, at its heart, our submission is that insofar as all three offenders, this case plainly crossed the custody threshold, and of course the judge found that for two of them, and significantly no sentence other than detention was appropriate. Before I turn to our submissions, can I hope, set out what we submit are the relevant principles derived from all of the matters that I referred to at the beginning, in other words, the statutory provisions, the guidelines, and the principal sentencing authorities. First, this. Whether sentencing an adult or a child, the seriousness of the offence requires consideration. For an adult, it is the beginning and the end, determined by reference to culpability and harm. The position isn't the same for children. A different approach is required, but the seriousness of the offending obviously cannot be ignored. To the extent that self-evident point needs to be made, it's paragraph 1.2 of the Children and Young Persons Guideline.
It is the starting point.
But the focus, of course, is rehabilitation where possible. And the expression where possible takes into account that there will be cases where the only appropriate sentence is detention. That, we submit, must follow. And the question is, was that the position here or not? In considering the seriousness of any offence, the court must, of course, take into account culpability and harm, but it must take into account culpability, bearing in mind that this is a child or young person. Again, I would hope that that is self-evident. To the extent that that's necessary to have any authority support it, it's paragraph 1.9 of the Children and Young Persons Guideline. Second, at all times, consistent with section 58 of the Sentencing Act, the court must have regard to the welfare of the child. That's a long-standing statutory provision from 1933, and the principal aim of the youth justice system is to prevent reoffending, section 37, as the court knows, of the Crime and Disorder Act. Third, and linked to the first point, if possible, sentences should be rehabilitative rather than punitive, but custodial sentences may be required, but only as a last resort, paragraph 1.3 of the Young Persons Guideline and section 6. Fourth, sentences should be individualistic, having regard to the age and maturity or immaturity and any other relevant matters such as mental health problems or learning difficulties, and so on. Paragraph 1.21 of the Children and Young Persons Guideline. Fifth, children are not to be sentenced as if they are mini-adults, ZA, paragraph 52. Sixth, if there is a youth-specific offence guideline, and I think there are only 3, I'm going to come back to that, it is generally unhelpful to start with paragraph 6.46 of the overarching Children and Young Persons Guideline, and we don't suggest that the judge should have gone past that. I'm obviously, as the court will have seen, taking a slightly different approach and tack than was taken at first instance before the judge, maybe not in relation to ultimate suggestion as to disposal, but in relation to the appropriate sequence and the application of the principles. But it may be necessary to go to the adult guideline, and here we submit that it is tolerably clear that it was, and to a far greater extent than the judge did. Those are the six, I'm not suggesting they're every single principle to be applied. The court's not going to be assisted by me going through the Children and Young Persons Guideline from paragraph 1.1 all the way through to the end, but I've hoped to encapsulate, as far as our submissions are concerned, important aspects of principle which we submit that our submissions are consistent with. As the court knows, we have set out in some detail our submissions in writing as to why these sentences were unduly lenient, and subject to the court preferring me to take a different approach, I'm going to deal with the matters in a slightly different order than I have set them out in writing. Can I just explain why? It may be of more coherent assistance for me to seek to address the specific criticisms that we make about particular findings or assessments first, because it's only once having done that to a certain extent some of the other arguments either crystallise or don't crystallise, and so that's what I propose to do. And so can I deal with that in this way? I don't know if the court would prefer every time for us to go to the sentencing transcript or not. I will obviously always provide the sentencing transcript references when I'm making a particular point in relation to...
We've got this well in mind and to hand, either online or in hard copy, so I think just far ahead.
Thank you. First, the judge made clear twice that previous consensual sexual activity was not mitigation. 44G and 46A, that's pages Y492 and Y494. That was correct. But he then approached the case on the basis that the earlier activity may reduce culpability. And we do submit that he does appear to have followed through in that approach when you look at Y500, 52A, and Y504, 56F.
I know this is unhelpful, but could you also just give me an internal page number?
Yeah, so that's, the internal page number is 52A. If you've got...
Don't worry, carry on.
Yeah, 52A, so page 52 and letter A, and 56F. That appears, from the way in which the judge articulated it, to be really an approach or a finding that he took in relation to X for reasons that are to a certain extent obvious because of the earlier consensual sexual activity. And then his conclusion that meant, because he says may at the beginning, but when you look at his reasoning at 52A and 56F, we would submit that it appears that he actually considered that to be the approach that he took. Now, the jury convicted of rape offences on the basis of there being obviously no consent and no reasonable belief in consent. And the judge doesn't, in our submission, clearly articulate why, where the offence of rape has been committed, there is reduced culpability. If it is age-related solely, then the judge has to be very careful not to double count that when applying, to the extent it's necessary to go to the adult guideline, any reduction. So there's a danger and a difficulty that arises there. But we submit that he's wrong in principle. An offender is not, as it were, less culpable. There may be other matters that don't arise, other aggravating features, but we submit that that was an error, and it can't be looked at in a vacuum from the other matters that we raise. Second, we submit the judge was wrong to conclude that neither victim was particularly vulnerable by reason of personal circumstances. That's at page 50F, Y498. We submit that they both were. I accept that one has to be careful about double counting and vulnerability and the number of offenders involved, but C1 was some significant distance away from home on her own. C2 had left her mobile phone and AirTag in the co-op. You know the sequence in relation to that, in relation to the offence of which X was convicted, then the break in time, and then the further offending. for Y and Z. And our submission is that in all the circumstances, they were both particularly vulnerable in their own way. Now, there are particular reasons also why the court knows that there was vulnerability, particularly in relation to C1. I'm going to return to that later. And the question as to whether a proper assessment of harm here should have ignored entirely the inherent vulnerability, bearing in mind the principle that one takes one's victim as one finds one. I would submit that the judge was wrong to discount that entirely. It plainly had to be given only the weight that it merited, given that the offenders weren't aware, but it was not irrelevant. Third, and this is a point which we submit that the judge's approach was clearly wrong, was in his conclusion in relation to severe psychological harm. 50C Y498. And this is in fact relevant to both the youth-specific sexual offences guideline and the adult guideline. Now, the court is well aware of the principles as set out in Chal, but here, the victim personal statements clearly set out that level of harm in our submission, especially when read alongside the harmed persons reports. So the court had ample material, and in our submission, the only finding reasonably open to this judge on that material was that this met that threshold. And that, we say, is as simple and as straightforward as that. You have been provided with further material, which the judge did not have, which would support that conclusion, but I accept that I have to get through the unduly lenient gateway, first of all, before the court can consider any new material. But when one considers those victim personal statements, clearly they're not victim personal statements produced within a couple of weeks or a month, as is referred to in Chal, of the offending. They follow a relatively significant period, and the poem written by C1 and the way in which C2 expresses herself, in our submission, the judge just provides no reasoning at all other than he's considered the relevant case law and that's it. And in our submission, that was simply not enough. He had to provide a significant justification. And can I just address one point which I think was raised below, which is Chal obviously makes clear that a judge is entitled to consider the demeanour of a complainant in the witness box. Real care needs to be exercised in the teeth of what the victim personal statements say if a judge is going to go behind that, and because a complainant comes across in a way that answering questions and appears confident doesn't mean that they're not suffering from severe psychological harm. So I'm not saying that the attorney would always have it both ways with that. In other words, if they break down all the time, that therefore there must be severe psychological harm. But a judge needs to be careful. And on the face of it, the judge has, we would submit, effectively rejected a clear evidential position insofar as this level of harm was concerned. And if we're right about that, that is a fundamental failure on his part. Now, it's not determinative of the applications, but it is, we would submit, consistent with the approach that he took, which, and I appreciate that I have to tread carefully here, but where you are sentencing in a case like this, the judge was plainly right to do it in two parts. That's what the judges are encouraged to do, it's what the training requires, it's what the judicial college compendium suggests in relation to a particular example, I think, which is in three parts. But where part two is going to set out, in the absence of the children, what the conclusions are, there is no excuse for failing to address issues such as this in detail. But harm is dealt with within a line and a half. It is it is cursorily referred to, and I appreciate the judge doesn't have to go into paragraphs, but given what the victim personal statements say, we submit that the judge did not properly grapple with harm here, and he should have done. Fourth, can I just deal with peer pressure? The judge's finding was that there was a large part of peer pressure in what went on. Now, we don't suggest that the judge wasn't in a good position to be able to form a view about that, but care needs to be taken in joint enterprise cases in relation to quite what weight one gives that. And indeed, there was on one view of it in our submission, and really the only view, was that if on behalf of X it is to be said there was peer pressure, the question arises, peer pressure from who on the facts of the particular case? So was it here peer pressure from X, sorry, or from Y on X, from Y on Z? What was the position? The judge just doesn't articulate that. He just sweeps up the fact that this is all peer pressure, and we ask the rhetorical question, from who and what weight should it have been given? Now, he makes it clear that he's placed significant weight on it. I'm not saying it was irrelevant, but looked at in isolation, I can see that I could well be given a significant hard time for raising that, but it can't be stripped away from the other criticisms that we make, because these were multiple rape offences, many of them being committed jointly. So, again, I'm not saying that it's not relevant, it's just too much weight was given to it. Fifth, the timing and location of the offending. The judge found it was not relevant to the assessment of the seriousness of the case. Page 56E, Y504. This was, we submit, an error. Each victim was raped on more than one occasion in the dark and outside. The logic of the judge's conclusion is to ignore why that is capable of being an aggravating feature. It may be that less weight could be placed on it than a situation where this was sexual offending from the outset, but to conclude that that was not relevant in our submission was wrong. Sixth, spontaneity. The judge only really deals with this on dangerousness at 55C, but can I deal with it in this way? We obviously are not submitting, we've made clear what we are and we're not submitting about this. Given the conclusions of the judge, which we don't seek to challenge, there was some consensual sexual activity in relation to both incidents. But in relation to, for example, the second incident and the criminality of Y and Z, that on the CCTV, I don't know if you have watched the footage of the flickering cameras or not, for 20 minutes, almost 25 minutes, with Y and Z. That is sustained, which is a different point. But in relation to this part of the case, in the context of the fact that there has already been, as the jury found, a rape committed by X, it's difficult to see that the judge's assessment that this was not spontaneous at all is really correct. Of course, it's not premeditated, it's not planned in the way that may have been suggested by the Crown originally, but that's a different point. Now, the judge only deals with it with dangerousness, so this is not a particularly significant point, but it is symptomatic, we submit, of some flaws in the judge's approach. At last, can I deal with perhaps the most difficult issue, which is the knife? As the court knows, we have considered very carefully what to submit and what not to submit about that, and we don't, as we've made clear, seek to go behind the finding of the judge in relation to the knife being used to take C2 to the scene, if I can use that expression, nor the specific finding as to the actual use of the knife. But, and I accept, of course, the judge heard the trial, the points I've already made. The judge expresses himself in rather equivocal terms, though, about whether there was a knife at all, and perhaps we can look at that, because that's 45E, page 493. So page 45. From E onwards, he says, now C2 alleged she was forced at knife point to go with the boys at the outset and then participate in non-consensual sexual activity. I'm sure this did not happen, and we, as we've made clear, we don't seek to challenge that finding. But I'm sure that even if a knife was present, it formed no part in any alleged kidnap and then forced sexual activity in any of the phases. There was no kidnap. So, I mean, the judge on a number of occasions keeps coming back to offences that weren't even on the indictment at trial. But then this, at the very most, an implement might have been used to cut her leggings. Now, I suspect the court will say, well, that's not a finding that he's sure, Mr. Little. It's just I can't say. But the evidential position, as far as that's concerned, was I accept, complicated, but you will have seen from the evidence that C2 is entirely consistent about whether there was a knife at all. On that, she was entirely unshaken, and there is simply no explanation for the 2 stab holes in the trousers on the basis of the evidence that was placed before the jury. So I, of course, accept that this is a high threshold and a high hurdle, but we put it, I hope, in a relatively nuanced way, which is to say that if he should have concluded, so he was sure that there was a knife and that C2 was aware of the presence of the knife, even though it wasn't actively used to actually commit the offence, then that must be relevant to culpability. And it's as straightforward a submission as that. Can I then turn, if I may, having dealt with those matters, to address specifically, therefore, why we say the sentences were unduly lenient, and that will require some consideration of certain aspects of the guidelines. Now, in this case, our submission is that there was clearly only one appropriate sentence, and that of last resort. We rely upon our criticisms of the judge's findings, but even on those findings, we submit it's difficult to understand how the judge could properly have come to the conclusion that he did, given the sheer number of rape offences, which the judge does not properly address in any way in Part 2 of the sentencing remarks. The underlying seriousness of the offending and the harm sustained. And allied to that overarching submission, we submit that is not inconsistent from taking an individualistic approach. An individualistic approach may require in every individual case for a child a sentence of detention. That, in our submission as a statement of principle, must be entirely unobjectionable. But here, we do submit, for the reasons I've to a certain extent already addressed, but just need to sort of distill, that his assessment of harm and culpability was fundamentally flawed. I've already made the point that there was only a line and a half in Part 2 of the sentencing remarks dedicated to harm. That's, for your notes, 45B and 46E, Y493 and Y494. That is, we submit, not just a lawyer's point. It is a substantive concern in this case, given the sentence that was imposed and the ultimate conclusion the judge took. I don't criticise the judge for setting out in detail matters relating to each of the individual child offenders. He was plainly right to do so. But the sentencing, Part 2 of the sentencing remarks read in an entirely lopsided way as far as that's concerned. And none of the underlying principles relating to youth justice in my submission justify that cursory approach taken to harm, and in particular his error about severe psychological harm. I've already made the point about victims, about offenders taking the victims as they find them, and I'm not going to repeat that. It was relevant to harm. And our submission is that he simply does not properly or sufficiently address the seriousness of each underlying rape, nor the number of rape offences for each of the offenders. And again, I've already made this point to a certain extent, but some of the aspects of the rape offences were sustained. I accept in relation to the first incident that the timing is not entirely clear, but on the evidence given by C1 in relation to the bus that she got and when she, Y came onto the scene, if I can use that expression. This was not a momentary or short-lived experience as far as she was concerned, although I accept that the evidence in relation to the sustained nature of the offending is clearer in relation to the second incident than the first. But the judge simply fails, for example, in relation to Y, to properly grapple with 3 rape offences committed in respect of each of the victims, and by reference, of course, one of those is a secondary party, but even so, this was a matter bearing in mind that both X and Y were convicted of rapes on 2 separate victims, which in our submission only admitted in this case of one answer, and that was not the answer that the judge gave. And I would submit that there's nothing inconsistent with that approach, given the seriousness of this case, and the fact that a custodial sentence should only be used as a last resort. But can I ask that we do go to the offence-specific guideline for children and young people, yes, please? As I indicated earlier, there are, I think this is right, only 3 such offence-specific guidelines. Robbery and bladed articles are the other 2. Bladed articles deals with a couple of offences, but they're similar. Robbery, just one offence. This guideline deals with tens and tens of offences, and it has to be looked at from the word go in that respect, because it is catering for a large number of offences that do not involve any form of direct contact at all, potentially, online, for example, and it can deal with a range of penetrative activity that is not non-consensual, and it can deal with penetrative activity that isn't rape, for example, and I could go on, but there's no need to do that. But when one looks at step 1 and offence seriousness, nature of the offence, in our submission, none of the matters for a non-custodial sentence apply, and I accept the judge just about gets to the second box, but he doesn't do so in entirely clear terms, as I'll come to in a moment, but he was dealing with, and in relation to X and Y, a number of rape offences in relation to 2 victims. And in our submission, one only needs to look at this, a custodial sentence or youth rehabilitation order with intensive supervision and surveillance may be justified where one or more of the following factors apply. Any penetrative activity involving coercion, exploitation or pressure, use of threats of violence against the victim or someone known to the victim, prolonged detention, sustained incident, and severe psychological or physical harm. Now, our submission is that all of those in their own way applied here, and then some, because this involved non-consensual penetrative activity. The use of the phrase use or threats of violence against the victim, I mean, the judge says that there was no violence here. Now, I understand that what the judge might have meant, but it's an extremely unfortunate phrase to use in the context of this offending. But it's difficult to see that a rape offence is anything other than violence. This is not the guideline that requires consideration about whether it goes above and beyond. But in our submission here, there was violence used against both of the victims by reason of the offending itself. The offending, we submit, was sustained for the reasons that I've touched on, and our submission is that there was severe psychological harm here. But for the judge to say at 50A that the rape offences fall more obviously into the second category, is indicative of his failure to grapple with the seriousness of this offending. So too, as I've said, stating that there was no violence at 50B. Then at step 2, so even assuming that one doesn't then pause and say, well, I am going to have to go to the adult guideline now, when one considers the aggravating features, the judge just refers to 2. And one danger in this case, where one's not looking at the adult guideline, where certain things that might be aggravating are implicit within a starting point, is that there are a whole host of matters of aggravating features that we set out in the final reference. And so again, the judge's approach in our submission was flawed in that respect. The judge then went to step 3, of course, considering the personal mitigation. We don't say anything about that. Step 4, reduction for guilty plea. It's only of limited consequence here, given what the guilty pleas were to. And then to review the sentence. The court must now review the sentence to ensure it is the most appropriate one for the child or young person. This will include an assessment of the likelihood of reoffending, the risk of causing serious harm, the children and young persons guideline for comprehensive guidance on sentencing principles and welfare considerations that should have in mind when sentencing children and young people, and for the full range of the sentences available to the court. Now, our submission is that any judge reasonably considering these facts, taking a step back, had to go then to the adult guideline. And to the extent that he did, as you know, our submission is that his approach was wrong in relation to categorization. Can I just deal with that, if I may, please? And that does require just to stand back and consider the underlying offending, and I don't need to go through the detail of it because the court is aware of it in relation to each of the offenders. But in relation to the adult guideline, if we're right about severe psychological harm,
And it's category 2A.
then it's category 2A. There is, we submit, an amount of additional degradation beyond the filming. I'm not saying that it would have got there on its own. It wouldn't. But a point that this isn't the first time I've made this point on a reference, but the court, just as it has to be very careful about double counting, it does have to assess what the individual facts are and consider what matters to count. And to a certain extent, there was an aspect of additional degradation or humiliation for both. And certainly in relation to C2, but we say in relation to both, these were sustained incidents. The judge, I entirely accept, the judge has to be careful about that when there are multiple offences. And I suspect that our primary point is really the multiple offences point as opposed to the sustained, but certainly in relation to C2, the offending is in our submission insofar as Y and Z is concerned is sustained. And we still maintain that one had to consider that overall. Now, obviously, the violence issue is distinct here because of the way in which it's articulated, so I'm not suggesting that. But in relation to culpability, we have here the offender acted together with others for some of the offending, and there was recording. So this was, if I can use the vernacular, category 2A, but I'm going to say plus, because what I mean by that is the court had to consider whether the nature of the matters, both relevant to culpability and harm, required an increased starting point from 10 years for an adult for a single offence before consideration of the aggravating and mitigating features. And our answer to that is we say that it did. And if that's right, and I accept that the exercise the judge has to undertake does involve an element of intellectual gymnastics to have to consider an adult in a situation where one is in circumstances where an adult is extremely unlikely to have been for a number of different reasons, perhaps not always. But to properly consider this guideline, because we do say it's engaged, it required a marked upward adjustment plus aggravating features before consideration of any mitigating features. But of course, one then has to be careful not to double count before one then considers what percentage of reduction is appropriate for age, immaturity, and all of the other matters that are rightly relied upon by my learned friends. But if that submission is right, then we submit that the sentence for an adult would have been extremely long, and that even applying very significant reductions to the sentences imposed on X and Y, for example, the sentence could not have been one that would have been anything other than a sentence of detention. And we've set that out in more detail in writing, and I don't think that I've really skated past anything that we make. The points we submit good as far as that's concerned, and the judge was wrong in his categorization. Now, I accept that the prosecution were contending for a different category. I would submit that that was not correct on these particular facts. This was, I would say, a category 2A series of offences for a single offence, but requiring upward adjustment before considering the aggravating and the mitigating features not implicit and not baked into that starting point.
Reference was made to the judge below, and indeed has been made, I think, by all parties before us, to the guideline for mental disorder sentencing. That guideline, of course, does not in fact apply
Right.
to offenders under the age of 18, so everybody has been wrong about that. Do you agree with that?
Yes. Yes, I entirely agree with that. I was going to come to that, but thank you, my lady. Yes. I mean, obviously there are factors set out there which have a relevance and an application for an overall assessment of culpability, but that is right. Now, I also accept that considering the starting point for an adult for the recording offence is maybe a slightly unhelpful exercise, other than to make the point that this is obviously a serious offence, and that if it is taken into account as part of the categorisation at 2A, is a further reason why there's a need for the upward adjustment, because that to a certain extent justifies that entire justification for that particular aspect of categorisation. But I'm not going to make any more detailed submissions about that. The judge was plainly aware of that. He regarded it rightly as an aggravating feature, and it is a very significant feature of this offending. But if it is part and parcel of categorisation, then other matters that are relevant to consideration alongside that then do justify that marked upward adjustment. And of course, both X and Y had a number of videos and images. I know that the court was provided with them. Some of them are obviously part and parcel of the same underlying piece of footage, whether screenshot or whether a smaller part of it. But this is offending which, or an aspect of offending which can have a very significant impact on victims, and has done, we would submit, in this case. Now, unless the court wants me to, I am not beginning to say that there were not significant matters that each of the child offenders could rely on here. Of course there were, in relation to age and in relation to the constellation of reports that were provided to the judge, in which he had considered. But we submit that those cumulatively, as far as each of the offenders are concerned, did not ultimately justify the eventual conclusion that the judge came to in terms of the appropriate disposal in this case. And therefore, they would and did justify a marked reduction once one got to the adult guideline, but they don't, in our submission, get to a position close to or even analogous to the position that the judge came to ultimately, having considered all of the facts of the case.
Well, Mr. Little, we all agree, I think, that every case must be dealt with on an individual basis. And I think in your written submissions, you accept that Z is in a different position to X and Y. The bulk of your submissions, on the facts at least, have focused on the offending by X and Y. What would you like to say about Z?
I was about to turn to him, in fact, so let me do that now. So he is plainly in a different position for two different reasons. The first is that he was only involved in one of the incidents. Well, actually, three reasons. He's younger, and his offending was secondary offending. It was encouraging, albeit there was also, of course, the recording. So the submissions that we make in relation to him, I think, really can be distilled in this way, that he, and I appreciate that it may be said, well, it's an individualistic approach, so there doesn't have to be the same type of architecture for sentencing for all of the children in the same way that there might be for adults. But plainly, the judge must have had regard to the sentences that he was imposing on X and Y in relation to the sentence that was imposed on Z. But we do submit that even though his offending is ultimately less serious for the reasons that I've given, and even though he has potentially more mitigation available to him, that first of all, an 18-month youth rehabilitation order was not the appropriate disposal in this case, and that because the judge has started, as it were, from the wrong place in respect of the others, the court does have to carefully consider whether the position insofar as he is concerned merited last resort only. And I hope that's a fair way to put it, that there obviously could have been for him a number of potential disposals, that the question, if the court concludes that this was not a case for which only custody was appropriate, then plainly the judge imposed a youth rehabilitation order. He couldn't, because of his age, impose a YRO with an ISSP. We're not dealing with a persistent offender as far as he was concerned. And we do maintain that because of the errors made, as it were, what I'll call upstream in relation to the other offenders, that still has a relevant consideration for this court, considering the appropriateness of the sentence that was imposed on Z in all the circumstances. But I accept that I have less points to make insofar as that's concerned, because it's obviously one single incident, and he is not involved in actual penetrative activity. So one would then have to consider carefully, as we've already been looking at, where this case fell within the youth-specific guideline and whether one ever needed to leave that. But these were sustained secondary party offences, committed and assisting somebody to commit them on a vulnerable victim in the circumstances that the court's aware. And so we would submit that did cross the custody threshold. But the court would then, I suppose, at this stage also then have to stand back and decide whether to intervene insofar as that's concerned. I don't know if you want me to address the question of double jeopardy in reply or
What's
to
your
deal with it
headline?
now. I've got two other matters that I do need to...
Well, why don't you do those, yes.
All right. So can I deal with dangerousness? And I accept that, and I very deliberately put this in the place that it is put within the submissions, because we say that one can only properly assess whether the court had to impose some form of extended sentence in the context of understanding what the actual length of the detention was going to be, because that's obviously a relevant consideration when assessing whether that is a necessary sentence or not. But we submit that the judge was obviously wrong to come to his first conclusions, and then the court, to a certain extent, has to consider that afresh as far as that's concerned. But in relation to X and Y, there plainly was material which is relevant to a consideration of dangerousness that went outside of the four corners of the matters that were before the judge in the trial that are set out in the pre-sentence report. Now, they plainly cause concern both for rehabilitation but also for dangerousness. The ultimate question for X and Y is whether really that sentence is necessary, depending on what the court's ultimate conclusion is in relation to whether the sentence was unduly lenient. I hope I fairly accept that if the court concludes that for X and Y detention was required, then the court may conclude that on the particular facts and circumstances, an extended sentence was not a necessary sentence. But that ultimately is a matter for the court taking an overall view of the seriousness of it. The judge obviously relies on a number of matters, but we say that he underplays the significance and seriousness of the underlying offending, which is also relevant to why his conclusion, as far as that's concerned, can be attacked. The other matter was just to deal with the duration of the restraining order. I hope, as you have seen from the material that comes, as it were, after the event, that this is a matter that has and does cause the victims very significant concern. Now, that's not the test. The test is whether it was necessary or is necessary and proportionate to impose a restraining order, as it were, for a period longer than was imposed.
The restraining order is limited to contact with the two victims.
Yes. And our submission is that on the particular facts of this case, with the material before the judge, that it was necessary and proportionate to impose a restraining order until further order. Can I then just perhaps deal with the last two matters? First, in relation to double jeopardy, and it may be fairer for my learned friends just to hear what I say about that. To a certain extent, I've already prefaced part of what I'm going to say. I ensured that the court was provided with what I would call the development of double jeopardy from French and Webster and then on to Afzal and Malik. And French and Webster does indicate that non-immediate custody and youth is a relevant factor as far as double jeopardy is concerned. I'm not saying that that principle no longer exists. It's a case-by-case basis as to whether it is invoked or not by the court. But plainly in Afzal and Malik, the Court of Appeal made clear that the development in sentencing practice, with perhaps far greater certainty to be able to advise clients as to whether a sentence may be referred by the Attorney General, had caused a change in the landscape. And there's good reason for that, because, of course, before the sentencing guidelines, it was always possible, a bit like finding a case to value a general damages injury, to find a particular authority for a Section 18 that justified a particular sentence when one was making an Attorney General's reference or whatever it was. But there is now far greater certainty and also a greater clarity, as given from Afzal and Malik, in relation to the fact that there are other interests in play as far as that's concerned. But it's obviously a matter the court will have to consider, but we do rely upon the fact that the sentence was imposed on the Thursday. There was national concern expressed on the Friday, rightly or wrongly, which meant that I think probably everyone knew that there was the possibility of an Attorney General's reference. And perhaps just because this is something which is in the public domain, which is not correct, is there have been certain assumptions that this reference was made without the sentencing remarks, which is not right, because the judge did upload his typed sentencing remarks. They weren't verbatim, but the decision was made over the bank holiday weekend, and on the Tuesday morning, which was really about the first possible time that this reference could have been lodged with the court, it was lodged. That is, certainly in the 17 years I've been doing them, the quickest reference that I can recall, and also the quickest listing. So those matters are relevant to the court's ultimate decision.
A lot of things were done quickly. One of them was the issue of a press release by the Crown Prosecution Service on the 21st of May. Do you have instructions, Mr. Little, as to when the correction of at least 2 fundamental errors in that press release were first corrected. 2 errors, I'd like to identify them orally. One, the press release suggested incorrectly that all 3 boys had been convicted of a knife-point rape. The judge made an express finding to the contrary. Secondly, the press release stated that C2 had been threatened with a knife, forced to leave her mobile phone and AirTag in a shop so that her movements could not be tracked. When was the correction made?
10th of June. I can provide an explanation for that if the court wishes. Or
I'd like to know what steps are being taken to prevent anything like this ever happening again.
Yeah. So what happened was that there was an original press release which was uploaded following the conviction, and then there was another press release which was produced in advance of the sentencing hearing, which proceeded obviously on a basis without knowing at that point what the judge's ultimate conclusions were going to be. But can I say this? The reviewing lawyer was present at the sentencing hearing and failed then to ensure that the corrections were made, which plainly should have been made immediately. I don't begin to suggest anything other than that. Obviously, I'm not here for the Crown Prosecution Service, but I'm here on behalf of the attorney who superintends the Crown Prosecution Service. That has been investigated in full. Whilst it is no answer to it, the reality was that on the Thursday into the Friday, everything was being done immediately to get the papers into the Attorney General's office in order to make a decision as soon as possible, and that was missed. It should not have been missed. It's been taken up at the highest level in the CPS, and I'm
How on
aware
earth
of...
could it have taken so long, given all of the inaccurate reporting about the nature of this offending that was swirling around immediately?
Well,
how could it possibly have taken till the 10th of June?
well, nobody pointed it out till then. I mean, that's the position. If it had been pointed out before then, I mean, it's not something, for example, that on behalf of the Attorney General, I would look at the sort of press release in relation to. I mean, I don't entirely accept the fact that was the sole cause of the concern in relation to the sentence, and I appreciate that my lady hasn't put it like that to me, quite rightly, but this was something which should never have happened, and I'm not beginning to suggest that it should have happened. But this has been taken up at the very highest level.
Released to the press. It has notes to editors.
I know.
It is there to be relied upon by the press. It's a very important document.
It's a very important document, and I can't do any more than say that this has been taken extremely seriously at the very highest level within the Crown Prosecution Service. But the underlying decision as to whether to refer was made expeditiously, and it was made on the basis of a proper understanding of the basis for sentence. And in fact, my understanding is that it was a person with a particular interest in the criminal justice system who pointed it out to the Crown Prosecution Service, and it was taken down the following day.
Well, and then reissued with the same date, 21st of May.
Yes. But if the court would want any further information about that, of course we can provide it.
Thank you.
But I understand the court's consternation and surprise and sort of failure to understand how it could take so long.
Well, how it could happen in the first place.
Yes.
And then how it could take so long. Thank you.
I think, but there is certainly now going to be guidance in relation to the consideration of ensuring that post-sentence any particular relevant findings of facts are then conveyed so that the press release is entirely accurate, which of course in 99.9% of the times it is.
As I understand it, there were also press in court at the time of the sentencing.
Yes.
Members of the press in person.
Yes.
Yes.
I might be... I think one as I understand it at least, some members of the press may have left in between part 1 and part 2. I'm not saying all did, but that's my understanding, is that some press members left in between part 1 and part 2. And so there were other aspects of the reporting which referred to some of the language that was used in part 1 in a way that has caused concern about language used. And there obviously is a vital distinction between part 1 and part 2. And so there can be a need, I think, for the press to be present for both part 1 and part 2 of this type of sentencing hearing. But unless I can assist the court any further, I appreciate I've been slightly more expeditious.
I think at some stage, and this in no way indicates the outcome of any of these references, we do need to have chapter and verse on number of days spent on qualifying curfew.
Yes.
Do you have that to hand at the moment?
I don't have it to hand, but I will. I
Have
will.
that over the short.
I
As I
will
say,
make sure that it's.
It may not be relevant, but in case it is, we would like to have those details, please.
No, and I can also probably agree it with my learned friends.
Good.
So.
You've made very good time, Mr. Little. You're running ahead of time, which
I
is no bad thing. Just give me a moment, Miss Wade, do you want to rise? Thank you, Mr. Little. Yes.
Ladies, subject to anything that the court requires me to do, I was proposing to take the court, your ladyship, through our respondent's notice.
Certainly.
In relation to X. Paragraph 5, we make the point that jurisprudence effectively, and I agree with my learned friend for the appellant in this respect, that jurisprudence in relation to sentencing of children and young people has largely developed since 2017.
Yes.
I don't propose to go through the guidelines in the children's sentencing, in the overarching guidance, but of course the twin principles of the prevention of reoffending and the welfare of the child are paramount. My learned friend refers to Crown and ZA reported at 2023 to Criminal Appeal Report Sentencing 45. And in our submission, and I think I submit this in relation to all three respondents, it cannot be overstated that underpins much of the jurisprudence now. In that case, obviously, the court will know that this court considered the sentence of 5 years imposed on a young 15-year-old in relation to a finding of conspiracy, a conviction of conspiracy to rob. It was serious in the sense that there were a number of defendants, and in particular two much older defendants, or older defendants at the time, who were 18 at the time of conviction and sentence. A series of robberies had taken place across North London, resulting in eventually the death of a taxi driver. The appellant in that case was acquitted of manslaughter, and the point was made that in establishing seriousness of the offending in relation to robbery, that acquittal needed to be taken into account.
How is this going to help us? The facts of ZA are so very different.
They are very different
to the facts here. I think the general principles
yes,
are established.
The principles are established, and they are set out helpfully at paragraph 82 of the judgment by Mrs. Justice May, as she was then. But the only reason I refer to that is in addressing the court on the culpability and the seriousness of the offending in relation to X, for example, the findings, the acquittals in relation to a number of matters are significant, and they are significant in relation to the assessment of seriousness in this case.
Why? I mean, we're just looking at the sentences imposed on X for the offences of which he was convicted. That's
correct, but as we go on to say in our submissions, on our written submissions, the offences for which he was convicted were effectively 2 counts of rape, the serious matters, 2 counts of rape in circumstances where the learned judge was prepared to find or agreed with the proposition that consent was withdrawn at a time when Y became involved and began to film those offences. But broadly, we submit, just getting to the reasoning that's been put forward by my learned friend, we submit that the learned judge approached the sentencing exercise correctly, and his approach was individualistic, as it should have been, and as Lady Justice May reiterated in ZA, that it should have been. The sentences imposed, broadly, in summary, the sentences which were imposed provide the best opportunity for the child offenders to learn and develop, and provide the most effective way, we submit, to protect women and girls in the future by the prevention of future offending. He did determine that the offences of rape crossed the custody threshold, but of course he was not required to impose, we submit, a sentence of last resort. My learned friend referred to the guidelines in relation to sentencing for sexual offences. The starting point there and submitted that the learned judge didn't, in fact, get to box 2 and the ascertaining of seriousness. Box 2 makes it clear that any penetrative sexual activity involving coercion, exploitation or pressure, use of threats of violence against the victim or someone known to the victim, prolonged detention, sustained incident and severe psychological or physical harm caused to the victim is such that a custodial sentence may be appropriate, or a rehabilitation order with intensive supervision and surveillance or fostering. It may be justified, and on the facts of this case we submit that it was. The learned judge made a number of findings of fact which I appreciate the appellant doesn't seek to go behind, and his findings of fact included, as has already been indicated, the fact that there was no planning, that planning didn't comprise any part of the offending, and the reference to that is in the sentencing remarks at page 50, the internal page 50F. He also found that C2 had put her phone and AirTag in the co-op by choice and not as a result of any pressure or coercion. She was not forced, as is conceded, at knife point to go with the boys at the outset, and even if a knife was present, it didn't form any part of forced sexual activity in either of the phases on the 17th of January. C2 was interested, and it was a specific finding by the learned judge, was interested in having sexual activity with X, and made it clear to him and others that the position and her demeanour changed after phase 1 on the 17th of January. The references are in our respondent's note. In addition, the learned judge invited assistance, and in this, it's really in this regard that we say that the respondents X and Y need to be considered separately. But he invited assistance on the interpretation of the verdicts, and that's why we say, lady, that it is important to consider the overall facts and what happened. And the learned judge considered that the defence submission, namely that filming initiated by a Y, was the catalyst for each victim to withdraw consent. And at...
I think that was just C2, wasn't it?
Sorry,
That was only the second incident.
Yes, the submission was made in relation to C1 as well, on the basis that initially the evidence was that she agreed that she had consented to having oral sexual activity. And I'm not referring, of course, to the matters that started before the emergence of Y and the other young person on the scene, but she did say in evidence that she had consented. She said, I think that's set out in the agreed facts of the reference, but it's certainly in the evidence and towards the end of cross-examination of C1. So on both occasions it was submitted that, in fact, what became rape because the defendant ought to have known that consent was being withdrawn in those particular circumstances had started as being consensual. And in the sentencing remarks at page, I think it's at page 46, internally, page 46C, the learned judge referred to that position as a cogent.
Yes, and that, as I said, that is the second incident.
It was
For each victim, I see.
yes. So it was being tendered as
Yes.
an explanation in relation to both
Yes, I see.
both victims, and
Thank
he
you.
accepted that as a cogent interpretation of the verdicts. He specifically asked for some guidance in relation to the verdicts, my lady, because there were obviously some acquittals in relation to X. And so just addressing then at paragraph 10 some of the reasons that have been put forward in the written application by the Attorney General. Obviously, we agree that the offences were aggravated in virtue of their being committed against two victims on two separate days. Don't seek to go behind that at all. But in relation to the broad points apropos aggravation, we say as follows. It's accepted that the camera footage shows why, and I make no apology for going into detail, because in the written application there is considerable detail in relation to what is said to be the aggravating factors. The respondent submits that C1's evidence, given under cross-examination, that she consented to performing oral sex, as I've seen, on X in the presence of Y and the third party, is important to the context, the overall context of the offending, which of course the learned judge was best placed to assess at the end of the trial. And as I've said, that the learned judge agreed with the defence submission apropos the interpretation of the verdicts, that it was the decision of Y to record the sexual activity that led to withdrawal of consent, and accordingly has submitted that the present actions of the group were intrinsic to the offending. The references for that are in the sentencing notes Y36 and Y500, at page Y500 rather. And I note that my learned friend says that it is wrong to use that as a basis for which he could reduce culpability. The learned judge could reduce the culpability of X. But the point is, we are dealing here with 14-year-old boys at the time of the offending. And the respondent submits that there's a risk, we say, of double counting in seeking to treat the filming of the incidents on both occasions as an aggravating feature. Insofar as count 6 is concerned, that being the second offence of rape which X was convicted, he was not present during the rape, and this goes really to the sustained and multiple counts of rape and the sustained offending, to which forms the basis of the application. He wasn't present at all during the rape of C2 by Y, encouraged by Z. While it's accepted that Y and Z attended the area of the rep, there was Y and C2 were engaged in sexual intercourse. There's no evidence that that was planned or anticipated, and indeed the learned judge already had found, as a matter of fact, that it wasn't planned. C2, rather's account of sexual activity was initiated and comprehensively undermined by the CCTV evidence and the oral evidence of the two witnesses. They're named there in the written submission, but the first of those, OEN, made an ABE...
W1.
Sorry. In her ABE video, K40, said this, well, we were in the toilet and X and C2 were just flirting, and C2 was asking him if he had condoms or something, and she clearly wanted to have sex with him, as he wasn't even sure about it. And then latterly, they were just talking about having sex, and C1 was, yeah, like, okay, I will, and X was not sure. We then have the ABE of the second witness, and significantly, her comments in relation to whether or not the evidence of C2 was undermined by the CCTV, fortify that.
As you've said, I mean, it's common ground that there was no planning. That's the point.
Yeah, that there was no planning, and that the incidents happened initially on the basis of consensual behaviour between the two of them, between X and the victims. It's submitted that that evidence is particularly important in relation to count 6. Before the commission of further offending against V2, the following aspects of that were highlighted, are highlighted, rather. Others were engaging X and C2, encouraging them to engage in sexual activity, and it's submitted that there is some support for this evidence heard on the CCTV. Now, it's difficult to disaggregate in our submission all of the points. They are disaggregated in terms of the application, but it's difficult to disaggregate them looking at the overall facts. And one of the points that we seek to make is that there was a certain degree of peer pressure, and we set out the details there in the application. And it's peer pressure from the other young people. Well, I've made the point, in fact, that the learned judge accepted that. And we submit that it was the presence and actions of the group, in light of the fact that consent was then withdrawn in relation to both offences for which X was convicted. It was the presence and actions of the group that were intrinsic to the offending, because it was the recording that took place. And there is, therefore, a risk of double counting in seeking to treat that as an aggravating feature as against X. Sustained, I think it's probably conceded that care needs to be taken in relation to the proposition that this was sustained offending, because there were multiple sequential offences, and I note that in his oral submissions, my learned friend has said that the learned sentencing judge failed to engage. In fact, the trial judge failed to engage with the sheer number of offences. But as I've said, count 1, and I've made the point already, I'm not going to repeat it, it's set out at C to D, was count 1 was effectively completed once Y had initiated the filming, but X's involvement was over as soon as Y said, "Do mine next." And there was no evidence of how long the period of offending on count 1 lasted. We simply don't know, and it would be inappropriate in our submission to categorise that as sustained. And the point being that X was acquitted of encouraging Y. So the point made is underpinned by the fact that X was acquitted of encouraging Y to rape C1. And as with count 1, in relation to count 6, it's submitted that the exact period of the offending is unclear, and that would be wrong to characterise the offending as sustained. There are 2 recordings at 9:32. of X and V2, C2 engaging in sexual activity. In the first, C2 is depicted performing oral sex on X, and of course the jury acquitted of that allegation, and the learned judge determined that that was consensual activity, obviously, and the recording shows the commission of count 6. The learned judge commended the analysis, as I've said, that the decision to record led to the withdrawal of consent by C2. And most importantly, it's of course a completely obvious point, but X wasn't in any way present when the later offences took place concerning YZ and C2. He'd left the area, and so it's submitted, even if the totality of offending, even if the judge failed to take into account the totality and sustained nature of the offending, then that cannot apply on the facts to X, because he simply wasn't there. Of course, we agree that the fact of the recording would have amounted to humiliation and degradation of both victims, but insofar as X is concerned, again, we come back to the proposition that it's not additional humiliation and degradation, and the fact of the recording by Y was again intrinsic to the offending on the findings of the learned judge. As far as the objection, as far as the proposition that the learned judge failed to take into account apropos harm the victims, the vulnerabilities.
Just forgive me, I'm
Yes.
just reminding myself. It is X, isn't it, who gives instructions to Y about what to film, and it's X who makes the comment that some might find particularly unpleasant about the offending in count 1.
Yes, in relation to
Isn't that additional humiliation?
Yes, I agree that that was the evidence.
Beyond
it was
the filming.
disputed, but obviously that was the evidence that was given by C1. And obviously,
It's what we can
there
hear.
was a
We can
plea.
hear on the footage.
Yes,
What he says.
we can hear on the
and
footage.
how he says it.
Yes, and there was a plea of guilty to the filming in relation to. And I suppose I don't want to reiterate the point, but it's the fact he does encourage him to film me or put the phone on me, but it's the fact of the filming that led to the withdrawal of consent we submit.
And the involvement of others.
Yeah.
These girls may have been willing to have sexual relations with X, but they didn't want to have sexual relations with anybody in front of a crowd.
Yes.
Maybe a small crowd, but a group.
Yes, that's right, my lord. Yes, but
So it's not just the filming.
it's not just the filming, but the filming. It's the filming that makes it a joint, a sort of, I suppose, a joint offence. And the point about that in relation to, I suppose it's on the facts, because the point about that in relation to, first of all, C1, is that she said that she consented in cross-examination. So that was clear. And obviously, she didn't know at the time, I suppose, that she was consenting that there would be the filming. But she did say she had consented. And in relation to C2, there wasn't any group offending. There wasn't a group offending until Y came on the scene and was then followed by Z at a later stage. So, and the acquittal in relation to count 5 must have the significance that they that my lord ascribes to the point, because C2 was happy, as the judge found to the criminal standard, that C2 was happy to have sexual activity with X until the point when Y emerged on the scene. and they had gone off separately. There was no group offending at that stage, at the stage when it was initiated. And it's important in our submission not to ignore that point. Of course, it's accepted that the victims had vulnerabilities, but it's accepted that the judge was correct to determine that V1 and V2 were not particularly vulnerable within the meaning of the sentencing guideline. And while it's noted that the Attorney General invites a departure from this finding, it's submitted that the court should be slow to accede to this submission, given the significant advantage that the learned judge had, having presided over the trial, and in particular having seen the witnesses together. He did consider it. He did consider vulnerability, and he did consider the severity of the harm.
But do you accept that particular vulnerability can be assessed not only by reference to what the offenders knew about the victims?
Yes. I couldn't derogate from that proposition, but it is also something which the learned judge was within his rights to assess in terms of what he could see and hear in relation to the evidence that was given. So it's something that the learned judge was in a good position to be able to.
Surely, whether they knew of the particular vulnerability is relevant to culpability, but it's not relevant to harm, is it?
We've
particular
said
vulnerability is a harm factor.
And we've confirmed in our written submissions that it's relevant to culpability. But I suppose what we would say is that it's difficult, as I've already made the point, it's difficult to disaggregate all of the factors in relation to what was quite complicated set of factual events. And one of the things that we'd highlight is the fact that these child offenders, all three of them, had their own particular vulnerabilities. And one of the things that Lady Justice May, or Mrs. Justice May, as she then was, stresses in her exposition of the sentencing guidelines in relation to children in ZA, is that the written reports and the assessments that are conducted by the Youth Offending Service are particularly important in relation to sentencing. And I know my learned friend doesn't disagree with that proposition, but those reports that were available to the learned judge were such that he was able to take an overall view in terms of vulnerability. So, for example, as far as X was concerned, there was the pre-sentence report, which deals with what had been assessed previously as a speech and language assessment. During a speech and language assessment, concluding that he had some language difficulties. And I note that that is something which has been the subject of further assessment since he embarked upon his youth rehabilitation order. So whether that's an lack of acquired learning, or whether it's an innate cognitive difficulty he has, there was a vulnerability there that the learned judge rightly took into account. And there was also the psychological assessment of Dr. Ward, which referred to his neurodevelopmental problem, his ADHD, and his anxiety. So when we're looking at vulnerability, it's important where we're dealing with children, and consistent with the rationale behind all the sentencing guidelines in our submission, to take an overall view and look at each of the participants in the events that underpin this trial. Again, we've made a point. The learned judge in our submission was right to find that the location and the timing of the offending in relation to both matters was not a specific aggravating feature. The location and the timing of the offending, the timing, first of all, was there was a temporal nexus between events which formed consensual sexual activity, a very close temporal nexus, and the location was again something which was exactly the same. And so it's not the location and the timing themselves that are aggravating. It's in some ways difficult to know what to say about the knife because the learned sentencing judge and trial judge made findings of fact and that no knife was used, and the whole of the factual scenario in relation to the second set of events concerning the C2 was based on her contention that a knife had been present, but it's certainly not accepted given the way in which the events occurred, that the knife was something that the knife was something that could be attributed to X. I've dealt with peer pressure already, but at paragraph 18, we spell it out yet again, that a 14-year-old boy in the situation that X was in, with his limitations, probably did succumb or would have succumbed to pressure. In relation to mitigating features, we refer obviously to the way in which X responded to both his bail conditions, his behaviour during the trial. He was the only defendant during trial to give evidence. He was present at all times during the trial, and we submit that that's indicative of the potential for rehabilitation. So broadly in relation to submissions, we say that the learned judge was in the best position to determine the seriousness of the case and whether a sentence which focused on rehabilitation was in fact possible in the context of this type of offending. And it's submitted that the suggestion that the learned judge failed to appreciate the seriousness of the offending is wrong or misconceived. He presided over the trial, and it was a lengthy trial. It took 29 days, and it's submitted that his determination that the offending of both X and Y passed the custody threshold was such that he was able, his determination that it did meant that he was able to impose intensive supervision and surveillance conditions. So broadly, in response to the matters that have been raised, this is not a case, we say, in respect of X, that the sentence of detention was the only appropriate sentence available to the learned judge, particularly in view of the focus on rehabilitation, which is necessary under the guidelines, and it's submitted that the circumstances of the offending were nuanced. Both victims consented, as I said, to engage with X initially, and he was not a participant in the further offending in relation, certainly, to what happened with C2. Furthermore, X was, as I've said, complied with onerous conditions over an extended period of time, all of which goes to the prospect of rehabilitation for him, and he's effectively, as we know, served an 18-month sentence of imprisonment by virtue of his qualifying curfew. He was away from home, staying with relatives throughout the time that he was on bail, or from when he was released on bail. He has no prior convictions, and he didn't offend, of course, when he was on bail. He has pro-social factors. His family support him, and he was, as I've said, fully engaged in the proceedings, and he has taken advantage, subsequent to trial, of the support which had been offered by the youth offending team. He would, as is emphasised in the pre-sentence report, be vulnerable in a custodial setting. He would be detained with pro-criminal peers, and he could fall under the influence of far more entrenched offenders, as is made, the point being made in the pre-sentence report. a youth rehabilitation order with intensive supervision and support does, as the writer of the report, the initial report, submits, supports rehabilitation, addresses risk, and is consistent, more importantly, with the principles for sentencing children. It provides a safe and constructive way, as she says, to manage his behaviour in the community.
So if it helps, I mean, it goes without saying that we have read in detail your helpful written submissions. So
yes, I'm just
go to the heart of your second, third, and I don't want to hurry you, but
thank you, my lady.
The headline points I think would be most helpful.
Yes, no, I think I've made the points that are most helpful in relation to the previous consensual activity. The only point I'd like to, whilst I'm addressing you, my lady, on the question of rehabilitation, is that X has participated fully in the supervision which has been made available to him. It's all detailed in the updated report from the youth offending team. But it's intensive, and one is sometimes surprised to see how intensive it is. He attends with his workers on 5 every day of the week and has a telephone appointment on a Saturday. He has missed no appointment, and he has availed himself of the opportunity of education and responds well to encouragement, as is stated in that report. I'm not going to repeat what we've said in the defence sentencing note in relation to harm. We submit that severe psychological harm was not was a finding that there wasn't severe psychological harm, was a finding that the learned judge was entitled to make, having not only read the victim personal statements, but seeing both victims giving evidence. Paragraph 36, we deal with in detail with the allegations apropos the knife, and the point of those paragraphs is simply to underline the finding of fact that the learned judge made in relation to the absence of a knife. I won't seek to repeat them here. Can I finish, please, in relation to just making some points which I think that I will be supported in by my learned friends in relation to the media reporting in this case. So once the Crown Prosecution Service press notice had been noticed, we did ask, and when I say we, I think there was a joint decision by those of us who represent the child offenders in this case that be taken down. But I think that leading counsel for the Crown was away at that time. In any event, there was one member of the press, certainly, who was in court throughout, a local press, who was in court throughout the sentencing exercise. And
did the local press report it accurately?
Yes, they did. I think they did. Some time after the national outcry. But the reporter did provide an accurate report, and she had been there every day of the trial as well. So
the point is, once the inaccuracies were swirling around in the media, that's the surprise, the basis for the surprise I expressed to Mr. Little.
Exactly, my lady. And I suppose
presumably thought, why on earth is that being said?
Yes, and I suppose it's very difficult to evaluate the public response if there's an inaccurate public confidence, I suppose, in the system and the justice system, and in particular the youth justice system, if there is inaccurate reporting in the media. So any evaluation is not going to be helpful. My lady, those are the submissions. Can I just turn my back for a moment, please? Just three other points in conclusion, my lady, going to the matters that have already been raised. First of all, my learned friend relies on in relation to vulnerability for C1 that she was far from home. Well, she was 25 minutes from home. That's the first point. The second point is that in relation to vulnerability and severe harm, the Crown reserved their position, having received the victim reserved their position on that point, and they didn't seek to argue it any further at the hearing, the sentencing hearing. And I have one other point. Oh yeah, my learned friend relies on, in terms of vulnerability, my learned friend relies on the fact that C2 was without her phone and AirTag, or certainly without her phone, which is not a particularly attractive submission given what the way in which the phone came to be deposited in the co-op and what was said about it. In other words, the lies that were told about it. My lady, I don't have any other points to make, subject to anything the court needs to know.
Thank you very much indeed. Thank you, Ms Wade. Yes, Mr Henry.
May it please my lady, members of the court. As the court is aware, youth justice has been one of the outstanding successes of the criminal justice system, driven by the twin imperatives of rehabilitation to prevent reoffending, combined with targeted intervention to enhance the child offender's welfare, not simply, my lady, for their sake, but for the benefit of society as a whole. And it was a matter of concern to the learned judge below to promote the safety of women and girls in the long run via rehabilitation, balanced with the urgent need for immediate and practical ways of stringently controlling these boys now and confronting their aberrant, indeed abhorrent behaviour. And this the learned judge well understood, but a wholesale attack has been made upon his approach by the Attorney General. And the judge, in our submission, was fully justified in passing the sentence he did. This reference invites the court to find that he acted in gross error, and it is our submission that he did not. My lady, what this court is being asked to do today is to send a 15-year-old boy of profoundly limited intellectual and developmental capacity who committed the first offence on the cusp of 13 and 14, and the second just a few weeks later, who is of good character, who endured what could be described as a short, sharp shock, who then served the equivalent of a 17-month custodial sentence on the most onerous conditions of bail, and who is now, my lady, actively engaged in specialist intervention designed to ensure that he never reoffends. But the submission of my learned friend for Her Majesty's Attorney General is that he should be sent to detention. And the Attorney General, of course, acts entirely within his constitutional rights in bringing this reference. But he has not engaged with the compelling evidence that the child whom I represent has a constellation of comorbid conditions that dramatically reduced his culpability. Now, the attorney's laudable concern for the victim's welfare does not and should not preclude a focus on the welfare of child Y with the aim of preventing child Y ever offending again, with all of the societal benefits that that entails. And that is what the learned judge sought to do. And my lady, in our submission, the sole question is whether the sentence was outside the range of sentences reasonably open to a judge who presided over the 29-day trial, heard all of the evidence, and applied the correct legal framework with conspicuous care. And in our submission, it was not. As this court well knows, Parliament has decided, and this court has repeatedly affirmed, that when sentencing children, an entirely different approach is required to that which the courts apply to adults. What the late Miss Forshall, King's Counsel, described as a root and branch difference of approach. That child-centric approach can produce sentences that would be unthinkable for a fully developed, mature, and sapient adult. But that does not render those sentences unlawful. It does not render them unduly lenient. It renders them what Parliament intended them to be: sentences shaped by clear and rigorous guidelines based upon the twin statutory imperatives of Section 37 and Section 44, applied individually to a child with rehabilitation and the prevention of future offending at their core. So those are my introductory remarks, my lady. Could I briefly turn, before turning to the legal threshold, the unique and troubling feature of this case so far as press publicity and the public outcry. We respectfully submit, my lady, that it was in substantial part generated by that press release, as the court has already made plain. Note to editors, which of course the press could supposedly rely upon, which of course described the latter incident of offending as a knife-point rape, and of course it was factually inaccurate and directly contrary to the learned judge's express findings. And I submit, as your ladyship has already, and I adopt, first, the categorisation of the latter incident as a knife-point rape was categorically wrong, and second, the assertion that the second victim was forced to leave her phone and AirTag because of the knife. None of those characterisations reflected the learned judge's careful findings, and the learned judge, as the court knows, expressly declined to find that a knife was used to coerce C2 into sexual activity. The second victim, C2, abandoned her phone and her AirTag of her own volition, and my learned friend, for His Majesty's attorney, does not seek to challenge that, of course, in the reference. As the court knows, it remained online until the 10th of June, and the public were accordingly misinformed, in part and substantially, we say, by the prosecuting authority itself. And it's relevant to, of course, any public confidence aspect to this case, because in our submission, the public confidence must be founded upon a sound and accurate appreciation of the learned judge's actual findings. It cannot be founded, my lady, on a public outcry that was itself the product of inaccurate reporting derived from the CPS press release. And in our submission, it has wider implications as well. Now, I must make this submission carefully, because Y behaved deplorably and disgracefully, and he, of course, deserves to be punished. But the public outcry, the opprobrium, the sheer force of hatred on social media and the like has gravely exacerbated his punishment since the 22nd of May. And as the court will know from the report of Dr. Harvey, the family have been advised to leave their home, They are on a priority list to be rehoused. That's Dr. Harvey's report at 2.28. And the super stigma in his community has made Y a pariah. He suffers nocturnal panic attacks in which he feels like he is dying. He is 15 years old, milady, with an IQ in the first percentile. As I say, he did serious wrong and deserves to be punished, but he has suffered substantial additional punishment that he is ill-equipped to bear because of the public outcry. So I now come to the child himself before examining the legal grounds. And the court, of course, is well aware of who Child Y is. And it is the answer to that question, who Child Y is, that we submit makes this reference particularly difficult to justify on grounds of, first of all, his level of functioning, which grossly compromises his insight, ability to reason, and markedly reduces his culpability because of his inability to think about consequences and limiting, of course, his impulse control. And I have given references to that in the annex to the RN and also at Miss Marcus's report at Q498, which just shows how compromised he is with his developmental language disorder in being able to relate to other people. As I say, he was 14 years and 24 days old at the time of the first offence. He was 14 years and 76 days old at the time of the second. And he presents with a constellation of serious, professionally assessed, and wholly unchallenged neurodevelopmental deficits. M2, Dr. Hathaway, a full-scale IQ of 66, in the bottom 1%. Mrs. Marcus, Q44, at Q486 to 582. Overall language ability at the 0.3rd percentile. So 99.7% of people of his age perform better than him. A language disorder formally diagnosed, his surface social skills causing others to overestimate his actual ability. ADHD, Mr. Cameron Ahmed, T23, formally diagnosed at a maximum severity across all three domains. And although it was only a screening at T24, significant concerns about autism, consistent with an autism spectrum condition. And the learned judge was entitled to, in our respectful submission, find that Child Y's IQ placed him at the bottom 1%, and that all other measures placed him no better than the bottom 4%. And he found extreme neurodevelopmental impairment, and that Child Y could not cope, for example, in mainstream education. And he said at 52G, internal numbering, he stated, "I am quite sure that," and I interpolate his, "culpability was reduced as a result of his profound impairments. His understanding of what went on must have been far more limited than a 14-year-old operating at a level without his deficits." Now, can I mention this in passing? The court will have had my descant on the Youth Justice Team's report on Child Y.
Yes. The short two-page note, the
Yes.
three-page note. That, yes, you've seen that. Yes.
And it describes that he has a very, very simplistic understanding of consent. In other words, he understands the word yes. Now, nothing that I am about to say is in any way intended to blame or to traduce the experience of C1. Nothing at all. But it will already be apparent to the court, having read the cross-examination of C1, notably carried out by my learned friend Miss Wade, that C1, as a coping strategy, did not reveal her true feelings and laughed and joked and went along with it, thinking that it was easier to go along with it than to resist. Now, she wasn't consenting, but it is an unfortunate feature of this case, so far as child-wise, very, very limited, unsophisticated understanding of consent, that the victim was, as it were, playing along with it, as was conceded in cross-examination. And the learned judge went on to say at 53A, child-wise impairment affected his ability to exercise appropriate judgment and make rational choices. His ability to understand the nature and consequences of his actions is clearly not that of an unimpaired child. Now, these are the findings that played a large part in determining the sentence, and the Attorney General does not challenge the substance of the expert evidence. He challenges the weight given to it. And that is a challenge to legal evaluation by the judge, not to legal error. And in our submission, it does not begin to reach the gross error threshold. And in our submission, His Majesty's Attorney hasn't engaged with this aspect of the case at all. Records that child Y found it difficult to stay focused, follow instruction, and had problems reading social situations, and I underline that, making him easily led, that he had not had sex before, that he appeared confused about the seriousness of the filming, and that his behaviour may have reflected susceptibility to peer influence and impulsivity. That's paragraph 13 of the pre-sentence report. Now, milady, after the clang of the prison gates, 20 days in local authority accommodation, many, many, many miles from home, in Wales at one point, and I think before that in Gloucestershire, child Y evinced a positive attitude to the regime that was set for him, paragraph 17 of Mr. Dallison. There was no offending or reports of antisocial behaviour throughout his long period on the most restrictive terms of bail, and the court has been provided with a chronology of those bail conditions, which is on the digital system, and his response to bail was described as exemplary by Mr. Dallison at paragraph 9 of the pre-sentence report, which the judge cited at paragraph 53B. And could I interpose at this stage? Child Y clearly developed a very, very productive and fruitful relationship with Dorset Youth Justice Service. But following the conviction and the relaxation of bail conditions which allowed him to re-enter Hampshire, because of course, as the court knows, he had been embargoed from Hampshire, living first of all in Ipswich and then in Dorset, separated from his mother, his father, his siblings, for a very, very considerable period of time. He has now been transferred to Hampshire, and no doubt, as a result of the conditions that he finds himself in, as a result of the public outcry, the firestorm, as it were, against him, and the fact that he is struggling with his comorbid mental health conditions together with a diagnosis of acute PTSD. In our submission, he is doing very well, notwithstanding the reservations that have been expressed by the author of the Youth Justice Report, in attending every session, and sessions, of course, that are 6 days out of 7, my lady. But to perform under conditions of acute PTSD, Dr. Jake Harvey, in our respectful submission, substantial credit should be given for that. And I come to Dr. Harvey's report.
Is it Y who's
Forgive me, my lady.
Is it Y who is going to work with his father, or is it X? I can't remember which one.
X.
X. Thank you.
X, my lady. Dr. Jake Harvey, CACD1 at dash 493, again, together with my précis, which has been uploaded onto the system. He is a consultant forensic psychiatrist of considerable seniority with specific expertise in young offenders, and he has assessed child Y. Now, of course, it is entirely a matter for this court, and I don't mean to be in any way presumptuous, but in our submission, with deference to the court, his opinion should carry weight, and considerable weight, because he is the forensic clinical lead for the South East of England Forensic Child and Mental Health Services, Child and Adolescent Mental Health Services. And as the court knows, I have précised his findings in an annex to the respondent's notice. And he concludes that child Y already meets the criteria for acute PTSD caused by the trial and the sentencing process itself, and severely exacerbated by this reference and its attendant media vilification. That is paragraph 5.13 of his report. And in Dr. Harvey's clinical opinion, custodial sentencing would repeat and intensify the very stressor, the anticipatory dread of loss of liberty, confinement, separation from home, that contributed to that condition in the first place, posing significant additional psychological risk. And child Y, in his opinion, is highly vulnerable to antisocial peer influence and exploitation in a custodial setting. And it is the opinion of Dr. Harvey that the structured community intervention now underway, halfway through, is actually reducing his risk, paragraph 5.21, and of course, again, entirely a matter for this court, but he proffers before this court the monograph of a 2,986 participant case study, a meta-analysis, which demonstrates that community treatment outperforms custody on rates of recidivism for adolescent and sexual offenders, 5.22. And as the court knows from documents that have been uploaded onto the system on behalf of Child Y, in a recent report of the experience of children in custody, and it's at page 26, table 18 of that report, the experience of children in custody was that only 18% of those children received rehabilitative work during their period of detention, and that was the sample that reflected that evidence. So Dr. Harvey concludes that child Y does not meet the test for dangerousness, 5.25, and very, very significantly, my lady, that his culpability was likely substantially reduced by his impairments, which he has described as severe, pre-existing neurodevelopmental disorders. So severe pre-existing neurodevelopmental disorders at paragraphs 515 to 517. Now, it is our submission, my lady, that the judge was fully aware of the implications derived from the expert evidence, and clearly intended to pass a sentence which was a direct alternative to custody, that shepherded child Y from childhood into adulthood, designed to address the risk he posed. Rehabilitation, in other words, not just for the sake of child Y, but for society as a whole. Can I briefly turn, milady, to the constitution of the court in the key authorities? This is already explicitly pleaded in the respondent's notice submitted on behalf of child Y. But both ZA and ATD were presided over by the late Lord Justice William Davis, former judicial lead for youth justice for England and Wales, subsequently chair of the Sentencing Council.
Yes.
And you have all of that. And that was the child framework that His Honour Judge Rowland applied. And we respectfully submit that the attorney has failed to engage with. We rely on JRO for, of course, the very succinct statement of principles in JRO, which in the authorities bundle is paragraph 17 of JRO at pages 41 to 42.
Thank you.
And there are 10, as it were, probanda that have been distilled by that court in the judgment of Mr. Justice Johnson. And I gave paragraph 10, or subparagraph 10 of paragraph 17. There is an expectation
tab, authorities bundle tab.
Authorities bundle, it begins, my lady, at 38, 038, but the paragraph upon which I rely is paragraph 17, which is to be found at 41 and 42.
Yes.
And point 10, there is an expectation that custodial sentences will be particularly rare for a child or young person aged 14 or under, and that, of course, as the court knows, comes from the guidelines, where there is the, as it were, the age back principle at 6.2, 6.1 having dealt with the occasions when an increase in the age of a child or young person will result in, etc., and the threshold given of 14 to 15. And then at 6.2, in such situations, the court should take as its starting point the sentence likely to have been imposed on the date at which the offence was committed. And moving on, milady, in ATD, and unfortunately the wrong ATD, and I shall come to it in a moment, the wrong Chapman are in the authorities bundle, but ATD is the last authority in the authorities bundle at 197, and I rely on at 214 to 215 paragraphs 46, 47 and 48. Paragraphs 46, 47 and 48. I read them out. Before we leave the case, we emphasise that our conclusion does not mean that the offence is committed against C, in particular the rape, which took place in the bathroom at her home, were anything other than grave. And then it continues, serious sexual abuse of a child aged 7 and 8. The sentencing process applicable to someone aged 15 at the time of the offending, and of course in this case, milady, 14, involves very different considerations to those which would apply to an adult offender. A court is obliged to apply the children guideline in those circumstances, which reflects the distinct statutory purpose of sentencing a person of that age. At 1.2 of the guideline, the core principle is expressed as follows: while the seriousness of the offence will be the starting point, the approach to sentencing should be individualistic and focused on the child or young person, as opposed to offence-focused. Paragraph 47, paragraph 1.5, the point is developed in this way, quotation, "It is important to bear in mind any factors that may diminish the culpability of a child or young person. Children and young people are not fully developed and they have not attained full maturity. As such, this can impact on their decision-making and risk-taking behaviour. It is important to consider the extent to which the child or young person has been acting impulsively, whether their conduct has been affected by inexperience, emotional volatility, or negative influences. They may not fully appreciate the effect of their actions can have on other people, and may not be capable of fully understanding the distress and pain they cause to the victims of their crimes." 48, an adult who commits serious sexual abuse of young children can be expected to understand the gravity of their conduct and to have a high level of culpability. The same does not apply to a person aged 15. It was a person of that age whom this judge was concerned for the purpose of sentencing. And of course, those words, we say, animated the approach of His Honour Judge Rowland in the present case. And of course, he was dealing with a child who was 14 at the time of the first series of offences and the second. So, dealing now with the legal threshold, and I'm concerned because the court is so familiar with the legal threshold. Do you wish me to address you?
No, we're very familiar with it.
I'm
It's a high hurdle.
I'm very grateful because the court is aware that the legal threshold, these are not merely introductory principles, they're the lens through which this whole reference must be examined. And we say the judge was particularly well placed, his conditions were in the range of reasonable responses, and the gross error threshold is not met on any ground. And the forensic advantage of the trial judge was exceptional, even by the standard of trial judges, because he stated at 43 F to G, which is at Y491, as well as trying this lengthy case, I dealt with a number of hearings before the trial involving applications for intermediaries and bail. Therefore, I know a great deal about each of the boys, and indeed the girls, aside from what emerged at trial. He confirmed at 43G that he had read everything uploaded to the case, and we submit that any court looking at this matter should be, and again I preface this with deference to the court, especially slow to interfere with evaluative findings made by a judge with that depth of knowledge, having presided over the 29-day trial, heard the evidence of all the witnesses, and had before him extensive expert material on all three defendants. And in our submission, the Attorney General's submissions do not engage with that forensic advantage. And I say this, the judge's concern for the victims is recorded throughout his remarks. He expressly referred to C1's victim personal statement and the harmed person statement at 45B, Y493, and to C2's victim personal statement and harm personal statement at Y46F, at 46F. And he stated at 43H, as I've said, that he'd read everything. And any suggestion that this judge was indifferent or failed to register the impact on the victims is flatly contradicted by those references. And indeed, at 47H, milady, Y495, he stressed that the boys should understand the effects of their behaviour on the two girls and their families. And he repeatedly referred to both girls as being brave and courageous in his Part 1 remarks. Regarding C1, he did so at 29H to 30D, Y477 to 478, at 31C to D, Y479, at 31 F to H at Y479, and regarding C2 at 32 F at Y480. So I come to one aspect of the legal threshold where I'm going to call it the public confidence formulation, where a judge has departed, and I quote, departed to a substantial extent from the norms of sentencing generally applied by the courts in cases of a particular type. And our submission is that he did not do so. There are numerous reported instances of YROs and ISSs being passed by courts in precisely this category of case.
Well, I'm not sure that's right. Precisely this category of case. Every case turns on its own facts. The cases that you've drawn helpfully to our attention are not similar on their facts.
Well, milady, ATD is, although of course it is only one victim, but it is sustained offending when she was 7 or 8, rape when she was 7, and forcing her to perform various acts and engaging in sexual activity when she was 8. And the court approved a suspended sentence designed to replicate the rehabilitative process of a YRO with an ISSP, which would have been appropriate had the defendant been a child. So I do ask the court to consider that. And it is also right, milady, from box 2 of the offence-specific child guideline, that can include penetrative activity, coercion, force, and the like. And the attorney has submitted that the judge didn't really go to box 2. In our respectful submission, he did. It begins at 49G to H in the sentencing remarks.
Thank you.
And it continues over to 50A to B. And I précis it. Step 1, seriousness, sexual activity without coercion, exploitative pressure may result in a non-custodial sentence. So that's box 1. Penetrative activity involving coercion, exploitation, pressure, violence, prolonged detention, or severe psychological physical harm may lead to a custodial sentence or YRO with ISS. And the judge went on, and I précis, rape offences fall more obviously into second category, given pressure implicit in absence of consent. And then he went on to say no violence or exploitation. But I move now milady, I wasn't keeping a record of when I started.
I was.
I'm very
12:15.
How long have I got, milady?
We'll rise at 1, but then you've certainly got 15 more minutes available if we
Well,
come
I'm very
back at 2.
grateful. Authority of N, the former Lord Chief Justice, Lord Chief Justice, he stated, milady, and it's at page 36 of the bundle,
Thank you.
the authorities bundle,
Yes.
that the welfare of the child or young person, having prefaced all of that, then says this, and I quote verbatim, "That is a matter of statute. It is not judge-made law. We are bound by it, as all judges are." Page 36. And we say the judge correctly identified and applied both duties. He stated these objectives expressly at Y495, placing them at the foundation of his sentencing analysis before engaging with any of the guidelines. And I quote, "I must have regard to the objectives of youth justice being to prevent offending by children and the welfare of the child." And his entire analytical structure thereafter was built upon the statutory imperatives. And my learned friend for the attorney, we say that his arguments are premised on the gravity of the offending. And we do submit that that is the wrong end of the telescope. The core submission, we say, no matter how artfully presented, is that this is an offence-focused submission by His Majesty's Attorney, and we submit that that is not the approach that should be taken. And then, going on to page 35 of the authorities bundle, youth as the most effective mitigating factor. Obviously, it's a principle of the greatest antiquity and force, and he restated it, Lord Judge, a stark, simple, unequivocal statement of principle, quoted Thomas on sentence, youth is one of the most effective mitigating factors. The principle has been repeated time and time again. And then at 36, he said this, even within the category of youth, the response to an offence is likely to be very different, depending on whether the offender is at the lower end of the age bracket, the middle, or towards the top end. In many cases, the maturity of the offender will be at least as important as the chronological age. And at paragraph 28, at page 36 of the authorities bundle, of course, the court in that case upheld substantial custodial sentences for D and N precisely because they demonstrated maturity well in advance of their chronological age. Child Y's position, milady, is the precise inverse. His developmental functioning is markedly below other children of his age, and so therefore we submit the principle in N, D and L therefore strongly supports a more substantial reduction, not a lesser one. And in the 1 minute I have remaining, can I briefly, if I just trespass beyond one by a very short period, if I may, milady, just to complete this section. Paragraph 1.2 of the Sentencing Council's overarching guidelines, sentencing children and young people, makes the statutory framework concrete in critical aspects. 1.2, the approach to sentencing should be individualistic and focused on the child, not offence-focused. 6.2, the court must take as its starting point the sentence likely to have been imposed at the date of the offence. You have that point already. 6.10, custodial sentences must be a last resort for all children and young people, and where there is an expectation that they will be, and there is an expectation that they will be particularly rare for children aged 14 or under. And all three defendants were 14 or younger at the time of these offences. 6.45, only if the court is satisfied that the offences cross the custody threshold and that no other sentence is appropriate, may the court, as a preliminary consideration, consult the equivalent adult guideline. And appropriate, of course, is not synonymous with possible. It requires active consideration of whether any non-custodial sentence can properly address the offender. 6.46, for those aged under 15, the guideline requires a greater reduction from any adult starting point than the half to two-thirds range applicable to 15 to 17-year-olds. And we say this, the learned judge applied this guidance scrupulously. I submit he conducted a textbook sentencing exercise in accordance with Chapter 14 of Child Defendants in the Crown Court. Textbook. He went through it to the letter. And as, of course, is clear, there has got to be, for a custodial sentence, there has got to be culpability. And I have already addressed the culpability mitigation as a result of the pre-existing profound and severe neurodevelopmental disorders. Milady, would that be a convenient moment?
It would be a convenient moment.
Very
so
grateful.
we'll come back, and Mr. Henry, you'll then have 15 minutes.
15.
15, yes, so the
I'm
hour
very
in
grateful.
total.
I hate to, this is not a souk, my lady, but could I ask for, I'm not seeking to bargain, but could you give me 20?
Well, let's see how we go. That's not an answer, Mr. Henry. Yes, Mr. Henry.
May it please my lady, the child is father of the man. Wordsworth's words reflected, we say, 2 centuries later when Parliament enacted Section 44(1) of the Children and Young Persons Act 1933 and Section 37 of the Crime and Disorder Act. Rehabilitation, the prevention of offending, the welfare of the child. And the child known as Y is father to the man child Y will become. The question, therefore, for this court, and one that it must confront, is what kind of man that will be. And the answer depends, to a very significant degree, upon what happens to him now. As the court knows, reoffending rates following custodial sentences for children are high, and we say the central issue is not the severity of the disposal, but its capacity to challenge and change behaviour. Now, the 3-year YRO with an ISS is not an unduly lenient disposal. It is a rigorous, structured, rehabilitative programme, precisely calibrated to address the flaws in Child Y's personality. And it presents, we say, the best opportunity to ensure that this child, for all the deficits that fate has visited upon him, becomes an adult who poses no risk to anyone. And the judge structured the sentences for X and Y so that if either passed his 18th birthday during the currency of the order, he would fall under adult supervision. That's 59H to 60A. So this is a disposal that tracks this child into adulthood, affording, as the judge stated, and I quote, the best prospect of rehabilitation and therefore the reduction of risk of further offending. That's 57A. That is not undue leniency. That is a sophisticated sentence designed to punish, but also to transform Child Y. And one wonders, because of course the attorney would never be so presumptuous as to present a figure to the court, but one wonders what the arithmetic is going to be if, as my learned friend Mr. Little King's counsel says, it must be custody, custody, custody. Because of course, as the court knows, Child Y was barely 14 at the first offence. The expectation of rarity of custodial sentences applied with full force. And time already served was a substantial factor. Child Y had served the equivalent of 17 months before sentence, 461 days on a qualifying curfew, equating to 231 days in custody. That's Y473 25G to H, plus 20 days in local authority accommodation, and he was remanded to youth detention accommodation, a secure children's home, the Hillside Secure Unit, and also Vinnie Green. And the judge identified this at page 53C to D, Y501, as a significant feature when determining whether an immediate custodial sentence must follow. And my submission to the court is that the Attorney General's submissions do not engage with the arithmetic of the notional, unspoken, unidentified sentence that he asks this court to pass. I ask the court to take as read the respondent's notice up to ground 4, failure to engage with the adult rape guideline. It's all been pleaded extensively. But so far as ground 4 is concerned, we say this ground is factually inaccurate because the judge followed the required 5-step process of sexual offences sentencing children and young people guideline to the letter, expressly stating at 49G, Y497, then I'm enjoined to follow a 5-step process, which I do. He then worked through each step in turn, culminating in the adult guideline as a preliminary consideration at step 5. And he addressed the adult guideline at 56A to B, Y504, as a preliminary consideration under paragraph 6.45 of the guideline. And he stated at Y504, at 56G, the mitigation I have alluded to, including primarily X's reduced culpability and Child Y's deficits, would significantly reduce any figure identified in the adult guideline before a very marked allowance of well over 66% as per the Sexual Offences Sentencing Children and Young people guideline, and likely more for child Y. And he confirmed at 57A Y505, I make clear the analysis of adult guideline is not necessary and does not determine the sentences. I simply make reference to it. And that is a correct approach that he was entitled to take, consulting the adult guideline as a cross-check and preliminary consideration, but not a sentencing framework. Let us postulate that this is a 2A offence. And we say that not even that is decisive, because a 2A adult starting point is 10 years custody, and a reduction of well over 66%, the minimum required for a child under 15, produces a figure below 3 years and 4 months before any reduction for child Y's profound neurodevelopmental impairment. And I do apologise to the court about the fact, as the Lady Chief Justice has noticed, about the mental health guidelines not applying to children. But the court, of course, is very, very familiar with the case of PS, Papa Sierra. And at paragraph 17, it states, his culpability may have been significantly reduced.
Sorry, Mr. Henry, you say we're very familiar with it.
Forgive me, my lord.
You say we're very familiar with the case.
Yes.
When they are anonymised.
Yes, I'm so sorry. It's not up on the system. I looked at it over lunch, my lord. I will send a copy into the court immediately after the
And what is the principle that it establishes?
Forgive me,
What is the principle that it establishes?
It's the principle that it establishes. It's got to be a purposive looking at the condition, because on the facts and circumstances of the case, mental health may not have materially reduced culpability. In others, quotation, his culpability may have been significantly reduced. And we say that this is such a case.
Do we need authority for that?
Papa Sierra. No.
Do we need authority for that?
No, I did.
Andrew?
No, I don't. For me, I don't think
I'm
we
very
do.
grateful. Now, there's the culpability reduction to do with his mental health and his neurodevelopmental deficits, but also, of course, the time spent in local authority accommodation, the profoundly onerous bail conditions, and the figure results plainly, we say, did not justify detention. The same, we say, would apply to a notional starting point of, let us say, 12 years, once the two-thirds reduction had been applied and further deductions for the profound neurodevelopmental deficits relevant to culpability, detention, etc., onerous conditions of bail. And I venture to suggest that even if we went up to 15 years, we would still get a figure of below 4 years. So I come to ground 5, dangerousness, and that was dealt with, of course, at page 55B of the sentencing remarks, where the learned judge gave 7 reasons for rejecting dangerousness. The ages of X and Y, the absence of previous offending, the spontaneous nature of the offending. I pause there to say that the attorney takes issue with that, but then in the same breath, Janus face, he says he doesn't suggest the judge should have treated it as premeditated or planned. So that must be spontaneous. The respective responses to custody and then bail restrictions, and then he said the contents, the learned judge, of the respective PSRs and prospects of rehabilitation. And of course, the 4-year threshold is an independently sufficient ground because, of course, Section 255 of the Sentencing Act permits an extended sentence only when the court considers that the appropriate custodial term would be at least 4 years. A jurisdictional gateway, not a discretionary consideration.
No, we understand that.
Forgive me, my lady.
Yeah.
Yes. And the learned judge found at 55B Y503, even if they were satisfied, then this is not a case where a sentence of 4 years would be imposed. So, my lady, we respectfully submit that the attorney has not engaged with the arithmetic. Can I come now? And I make it absolutely
just pausing
plain.
there,
I say
just so
the
everybody
sentence was
understands. Just wait a minute.
Forgive me, my
Just so everybody in court understands, the 10-year starting point is for a single 2A offence for an adult.
Yes, that's why I postulated 12 and then 15.
Yes, you did. Yes, you did.
Yes, bearing in mind, of course, totality.
And we've got on the image offences, what's the range? What's the range for image offences?
Again, we have to have respect for totality.
Of course.
So I would not be submitting that those would be, let's say, dealt with as consecutives. But
would you deal with the two victims?
forgive me.
Would you deal with the two victims
Of
consecutively?
course, my lady, we must deal with the two victims.
But not necessarily by consecutive sentences. They could be dealt with by each resulting in a longer sentence than would
Overall.
otherwise have followed if it had only been one offence. Either approach is acceptable.
Of course.
Yeah.
But I have tried to take, let's say, a top-line figure of 15 to make a sensible assay of what the court is being required to do,
Okay.
given all of the reductions that in the learned judge's discretion, and of course he had presided over the trial and he was uniquely privileged to make those decisions. Now, of course, I don't for one moment suggest that the sentence passed was anything other than justified, but I have to address double jeopardy. And in my respectful submission, and it's not in the authorities bundle, but it's on the digital case system, Lord Lane's residual discretion to decline to intervene even when leave is granted. And it's CACD 1-453 at CACD 1457 that the court might properly decline to intervene where to increase a sentence, quotation, would be unfair to the offender or detrimental to others for whose well-being the court ought to be concerned. Now, of course, in Child Y's case, the welfare of the child is not merely a mitigating factor. It is a statutory imperative under Section 44(1), and it doesn't cease to operate at the point of a reference. Child Y, as stated, is actively engaged in specialist harmful sexual behaviour intervention under rigorous supervision, and to increase his sentence to one of detention now would disrupt, even destroy, a rehabilitative trajectory that represents, as I have already submitted, the most effective long-term protection of the public, and the discretion should be exercised to decline to intervene. But if the court, and I don't say it should be, but if the court is not moved by these submissions, then meaningful, not nominal, reductions for double jeopardy are invited, because, of course, the weight of suffering, not knowing one's fate, and being hounded as if the whole world is against one, especially since the 26th of May, is significant. And this is a matter that this court should weigh when assessing the quantum of any double jeopardy reduction. I refer to him as a pariah and the hatred directed towards him. And reference has been made to the fear and isolation of the family by Dr. Harvey. Secondly, even before conviction, there was that fear, but of course it has been exacerbated, and Dr. Harvey deals with it in depth, but it has been exacerbated very considerably by what has happened since the 22nd of May in the public arena. And then thirdly, he has already served the equivalent of 17 months by way of qualifying curfew, 20 days in youth detention, and completed a period of the YRO requirements. And leaving aside all questions of press vilification, the aggregate burden he has borne significantly exceeds what would have been borne by an unimpaired adult defendant in comparable proceedings. And of course, you have Webster and French, and it's at page 181 of the authorities bundle, the Lord Chief Justice at paragraph 61, and I quote, "The distress and anxiety is likely to be particularly great where the decision of this court results in a defendant being placed in prison where originally no custodial sentence was imposed, where a custodial sentence has been completed, where the defendant is young and immature, or where the defendant was about to be discharged from prison. In all of these cases, the distress and anxiety caused by the double jeopardy is likely to be significant when weighed against the original offending. The authorities show that in such circumstances, discounts for double jeopardy tend to be granted that are near the upper end of the range. Now, nothing that the subsequent Lord Chief Justice, my Lord Chief Justice Thomas, said in Afzal and Malik derogates from that principle, which still survives and which I respectfully commend to the court. So, dealing with it very, very briefly in my last closing moments, my lady, the correct legal threshold is gross error, and it has not been established on any of the 6 grounds, individually or cumulatively. And I cite Chapman, CACD 1-427, unfortunately the wrong Chapman is in the bundle, Griffith-Davis, in the bundle at pages 125 to 126, so far as paragraph 29 is concerned, which I rely upon. I respectfully submit, notwithstanding the very attractive way in which this has been put before the court by His Majesty's Attorney, that this is an offence-centric submission. And that is not in accordance, I submit, with ZA or ATD. That the learned judge was required by statute to have regard to the prevention of reoffending and the welfare of the child, as the Lord Chief, Lord Judge, stated, that it was binding on all judges. It was not judge-made law. I commend to the court youth and also, of course, the preamble to the sexual offences guideline, which I respectfully submit, the youth guideline, which I respectfully submit, encapsulates the circumstances of this case, where I quote, sentencing a child or young person for sexual offences involves a number of different considerations from adults. The primary difference is the age and level of maturity. Children and young people are less emotionally developed than adults. Offending can arise through inappropriate sexual experimentation, gang or peer group pressure to engage in sexual activity, or a lack of understanding regarding consent. And then I omit words. And it is not difficult to understand how we get to peer pressure in this case, milady. It is the group dynamic between these boys, the fear of missing out at a time of great hormonal changes and puberty, and the desire to emulate another child's example, however deplorable it was. So we respectfully submit that the age-back principle recognises that child Y was barely 14 at his first offence, that his profound neurodevelopmental impairments justified a finding of reduced culpability, and that the learned judge's conclusion was within the range of reasonable responses, that the time spent on remand, both, as it were, in custody and on the most stringent conditions of bail, was also properly weighed up by the learned judge. And we conclude by submitting to the court that leave should be refused, that the learned judge went through this in an exemplary fashion. I've dealt with the factual challenges that my learned friend, Mr. Little King's counsel, has made in my respondent's notice, but I end finally on psychological harm, which is obviously a matter of concern to the court. And in our respectful submission, the learned judge applied Chal and others, 66 of the authorities bundle, and he expressly cited this at 50C of the sentencing remarks at Y498, to borrow respectively the words of Lord Justice Popplewell at paragraph 28 in Price. I do not seek to minimise the effect on each girl. when saying it does not reach the high threshold of being severe psychological harm required by the guideline. And we say that that is a textbook application of Charles. He was not dismissing the impact. He was applying a high legal threshold. And that finding is unexceptionable. My lady, unless I can assist, and may I thank the court for its indulgence of me. I see you've given
No
me...
indulgence. I think you've been faithful to your time slot, Mr. Henry, and been very helpful. Thank you for your submissions. Anything? No. Thank you very much indeed. Yes, Miss Ayling.
Please, my lady. We rely on our respondent's notice. We rely on our respondent's notice, which we have served, but perhaps more importantly, our original sentencing note before the learned judge at the time of sentence, which is quite extensive and deals with all the principles which have been laid out before you in this court. And so I hope to be succinct but not disjointed in my submissions this afternoon. I will deal with various matters, but I am not going to go through any of my documents. We rely on them, and as you know, we've tried to put into our respondent's notice everything that the judge said which was important to the case of Z.
So there were two sentencing notes from you below.
Yes, that's right.
Yes.
The second one followed on from a Crown note with
Yes.
which we did not agree. In our respectful submission, Z is in a different category from the other two defendants. He is younger, he was 13 at the time, and this court must have regard to the overarching principles that custody is a last resort. That's quite clear from the sentencing guidelines 6.10. Custodial sentences must be a last resort for all children and young people, and that they will be particularly rare for children and young people under 14.
Ailing, so far as children who are under 15, one of the reasons, of course, why custody is going to be particularly rare is because they would have to be a persistent offender in order to be sentenced to a detention and training order. So anyone under the age of that would need to be in the Section 250 category before custody could even be contemplated.
Yes, indeed. And I listened with care to the words of the Attorney General's Counsel because a detention and training order is only available if he is a persistent offender. The other form of detention could be a sexual offence 249-250, but that would be a long-term detention, and under Section 251, it can only be imposed if neither a YRO or a DTO is suitable. And the word suitable is important, and in this case, we submit that the attorney has not addressed you on the mechanism by which this child can be sentenced to a detention and training order, and still hasn't. It's not in writing, and it hasn't been addressed today. And it would be, we submit, a very strange thing indeed if the first two defendants were sentenced to detention and training orders, and because a detention and training order isn't available for Z because he's not a persistent offender, that the court would then look to sentence him as a long-term detention order. And so we submit that just hasn't been addressed. It's right, though, that in Zed's particular case, that this is not repeated behaviour, and he will benefit from addressing the issues to change his conduct. And you've seen from the Youth Justice team that's particularly true with regard to consent, and it falls squarely, we submit, between 1.1 and 1.6 of the guideline, that the priority should be to address his behaviour. Having made that point, which is my main point, I now become a little sporadic, so forgive me. I want to address one or two things that the attorney has said in his submissions today, and that is really the specific offending guideline. sexual offences and the two boxes to which Mr. Little refers. And he's not quite right, we submit, in relation to this. You've already heard that the learned judge addressed the two boxes as far as where he should pitch the seriousness of the offending. Yes, rape is a violent offence, of course it is, but box 1 quite clearly indicates that a non-custodial sentence may be the most suitable disposal where one or more of the following factors apply: any form of non-penetrative sexual activity, but any form of sexual activity including penetration without coercion, exploitation or pressure, except where there is significant disparity in age. Penetration can be rape. Therefore, it does not mean that rape is excluded from box 1. It doesn't say except in cases of rape. So the fact that...
Just to interrupt, in one sense, of course, this is an offence-specific guideline, but it's a very unusual offence-specific guideline,
yes,
isn't it?
Yes, absolutely.
Because it covers such a huge range of offences.
Yes, it does. But
so you're gone.
I'm sorry, my lady, I interrupted you.
No.
I was just indicating that there is an element of extra violence in rape to get it into box 2 rather than box 1, because box 1 does include rape, because rape is also penetrative.
It doesn't say anything at all about consent.
No.
And many people would think that consent was a particularly important question when considering sentencing in a case of rape.
Absolutely, but the attorney relies on box 2 very specifically, because the attorney says that the judge didn't look at it as box 1 and box 2. And all I'm saying is that can't be right, because the guideline allows that even in a case of rape, a non-custodial sentence is still available to the court.
Well, in respect of box 2, the word is custodial sentence may be justified.
Yes.
In other words, it follows it equally may not be.
Yes.
Even if it's in box 2.
Even if it's in box 2. But the main point is that the learned judge did consider both boxes. Whilst on that guideline, may I just indicate that although your ladyship said that we all relied on the mental health guideline, in fact we didn't. We rely on this guideline under personal mitigating features, which includes mental health concerns. And so no authority is required. It's there in that specific guideline. I don't think at this point that I need to address you in relation to any factual matrix unless the court wishes me to.
Thank you.
Thank you very much indeed. Then that is all I have to say in relation to Z. But may I please say this? The publicity in relation to this case has been particularly unfortunate. That inaccurate press release led to a judge being vilified, a petition calling for his resignation as a judge was instigated, a very young defendant being terrified to leave home, and political comment. And in the time-honoured tradition of the bar, none of us being able to do anything about that and put the inaccuracies right. And so many things have been affected by what happened by that.
The dangers of speaking out without a proper understanding of the facts are starkly highlighted in a case like this.
Yes. No one has addressed you on the restraining order. You have our submissions in relation to that.
Yes.
It is because it is a long period of time. Even a 10-year period for Z means he would be 24 by the time it stops. The disclosure and barring service require that to be indicated, and one needs a disclosure and barring application for almost every job now.
In terms of proportionality, what does it prevent your client from doing?
It would be on his record if he wanted to get a job.
Yes.
That's what it would do. So far from rehabilitating, it would mean he may be stopped from working. So, I mean, one needs a disclosure and barring indication for any job, just about nowadays. And so even...
And a restraining order triggers that in a way that an expired order doesn't.
Yes. It would expire after 10 years, but it would be on his record for 10 years.
Yes.
If it's any longer, then it would probably stop him from working for even longer than from when he's up to 24.
And is that a position that would apply to all 3 offenders?
Yes, it would.
Sorry, Ms. Hayden, do you know where that's set out? What is the statutory provision?
I can check that. We will check that and let the court know. I'm sorry, but that's just known to my learned junior who practices in this area on a regular basis. I don't know if I can assist the court in any way. I really have been very short, but only because the attorney doesn't seem to indicate how we have a detention and training order.
No, thank you very much. But if your learned junior could email that to the court
Yes, certainly.
Immediately, that would be very helpful.
Yes, certainly.
And obviously copy everybody into that, please.
Yes.
And before going back, thank you, Ms. Ayling. We obviously have your written submissions both here and below.
Thank you.
Before going back to you, Mr. Little, would any of the junior bar like to follow any of their leaders in any way at this stage? No. I'm sure that you've all been doing a lot of the hard work as well, so your
I wonder if the
presence
court
is
could
not
indicate to us
overlooked.
how we would email you that information, which we have. Thank you very much.
Thank you very much indeed. Okay.
Lady,
Yes.
I'm very sorry to rise again. I have forwarded to the registrar the case of P, which deals with mental health.
Yes, I found it now, Mr. Henry, thank you, and I do remember it.
Thank you.
Were you in it? Okay. All right. Thank you very much indeed. Yes, Mr. Little.
Well, my lady, I don't have very much to say in reply, although much has been said that we haven't engaged with the mathematics. This court generally is not particularly well inclined to over-arithmetical Attorney General references.
What do you say about a DTTO for Z and how that would work?
Well, our submission is, of course, that this was a grave crime in relation to all 3 of them. And so that's my answer to that,
yes.
If that is an answer to that. But the court will also have to consider if a DTO is not available and that the appropriate sentence was a youth rehabilitation order, whether this particular youth rehabilitation order is of sufficient duration, for example, or not. But at the heart of our submission, of course, I think as is clear from the outset, was that this was a case of such severity that it required detention for all. And I'm not intending to get involved in the mathematics, but the court has made general observations in relation to the fact that there are a number of offences that required consideration here, and we made crystal clear in writing where we said this case would fall, to the extent it was legitimate, were these defendants to have been adults. Oh, sorry, my microphone's off.
Yes.
In relation to days and
Qualifying curfews.
curfew that you asked about.
Yes. Have these been agreed?
Yes, I've had discussions with my learned friends about this. So the position is as follows, that there were 461 days for both X and Y, which would, of course, have to be halved, so it's 231, in fact. I think the Crown said 462, but it ends up as the same calculation of 231 as a half. And on my calculation, there are the days that don't properly count from the start for both of them, or don't automatically count, maybe the better way to put it.
I'm not sure about that, Mr. Little, because they were, although the phrases youth detention and detention to local authority accommodation have been used almost interchangeably, looking at the original warrants and the court's extract from the magistrates' court, they appear to me to be youth detention, which does count.
Yes, well, I hadn't noticed that, so I apologise.
Automatically?
Well, yes, quite, that does count automatically. The only other period of time, to the extent that the court wants to consider it, is that I think, as my understanding is, that all three of the child offenders have been subject to post-sentence curfews as part of the sentence. So since the day of sentence, as part of the youth rehabilitation order, I think all have
Yes,
curfews.
they had a 3-month. They each had a 3-month curfew. I think they each had a 3-month curfew.
Yes, quite. So to the extent that the court decides that any of the sentences are unduly lenient, the court may have to consider what account, if any, it wished to take about.
But it's not a qualifying curfew in the same way. It's a discretionary issue.
Quite, absolutely.
Yep.
So I think that's ultimately it's a matter for the court's consideration. But unless the court would wish me to address anything specifically.
Well, what about the point about extra violence being required for box 2?
Well, a couple of points, if I may, about that. Most of them I've sort of made to a certain extent, which is that, as always, these are not to be looked at as if they're a statute. The points I've already made, that this covers a wide raft of offending, and in relation to the nature of rape and violence and consent, my submission is that, and I'm not going to say never, but almost without exception, offences of rape such as occurred here would fall into that second box. And the reference to any form of sexual activity, including penetration, in the first box could potentially cover a wide range of offending that isn't rape. And so I'm not going to say that it would be impossible ever to have a rape case that might be considered to not fall into that second box, but it would be vanishingly rare in my submission. Now, I accept that might be said to be not a very individualistic approach to take in relation to the sentencing of children, but my submission is that that the judge was very specific when he said there was no violence, and that was at least an unfortunate turn of phrase, but was incorrect as a matter of fact. And that the judge's approach to these two boxes, we say, was flawed for the reasons I've already set out.
Can I just ask about the restraining order, whether
Yes.
you're able to help us about the consequences of it, which we were informed of a few minutes ago?
Well, that's obviously a matter for the court to consider, but it can't be the only consideration.
Is it right? Is it right that it affects employment prospects simply by nature of its existence?
Yes, as I understand, it would have that potential impact in relation to employment rights, but that is a consideration for the court. But in my submission, that's not an entire answer to the question on the facts of this particular case.
Right.
Understood. Thank you.
Mr. Little, thank you. You can sense the deep concern of the court as to the circumstances surrounding the press release.
Absolutely.
Both at the beginning as to how it came to be released at all, but in the context of the very significant media reporting and general social media reporting that was so clearly inaccurate, why nobody, either on the Attorney General's side or on the CPS side, corrected any of those inaccuracies, given the consequences, inevitable consequences, is troubling. So if there is anything that you can provide the court with in terms of information as to steps being taken, you said it's being dealt with at the highest level. There's no letter of apology, there's no letter of explanation, there's no information for the court as to what exactly is going on.
All right.
It may not be feature in any judgment, but it is something that we are troubled by.
I entirely
And we are considering, what our options are. So I just, we are where we are now, but you hear us.
Yes, well, quite. I mean, I can provide some more information about what's happened, or we can put that in writing, whatever the court would prefer.
Mr. Little, could I just throw this in? Earlier on, when you were dealing with this, you quite rightly said you're here for the attorney rather than the CPS. I understand that. But I think the attorney personally actually made some observations about the case, I think in a podcast of some kind. I'm not sure he corrected what had been said when he did that.
No.
All right, well, I will raise that matter. But what I can say to the court is that all Chief Crown Prosecutors have now been instructed to remind all reviewing lawyers that they must check every press release that goes out following a sentence where the judge does say anything which could depart from the assumed basis. And so, as I indicated earlier, there was an original press release post-conviction which went out that proceeded on
yeah,
the...
I understand that. I'm troubled by that, but I am just as troubled by the heat and the political energy around this particular issue. I'm not looking at any particular party, that nobody appears to have stepped in to correct the basic facts, and it was the headline. Knife point rape was the headline, and it was just wrong.
Yes.
Thank you. Now, we've obviously got a great deal of material to consider. At the moment, we hope to be in a position to see the offenders tomorrow at 2 o'clock in the afternoon. If you have not heard anything to the contrary by 6 o'clock this evening, I think you can proceed on the basis that that is what is going to happen. If that changes between now and 6 o'clock, we will contact everybody, obviously, as a matter of urgency. But assuming that that is the case, X and Y, I know, are going to be at Southampton Crown Court. Miss Ayling, I had a slightly confused message about the position of your client.
Yes, and we received notification from the attorney's office that you couldn't compel him to attend, and so he wasn't going to. But if that is wrong, then he will attend Southampton Crown Court at 2 o'clock.
No, well, haven't been copied in or shown that correspondence. Perhaps we could be sent it, and I don't know whether that is the correct position or not.
We certainly made representations about it, and I inquired whether there was an answer to those representations, and I was told none was necessary because the court couldn't compel attendance. So if that is wrong, then the defendant will be there at 2 o'clock tomorrow afternoon.
Right. Well, perhaps somebody could send us that correspondence.
Yes,
right. Now, we will want to address X and Y directly, and we will use their first names. I have alerted the broadcaster to that, but I just remind everybody in court of the reporting restriction that applies to the boys. And I would, obviously it goes without saying, expect that to be respected. There should be no reporting of their first names in any way, shape or form. And I know that the Sky representative is making arrangements to make sure that nothing goes wrong. We would then, after a short oral exchange with the boys, proceed to give our judgment, and we will decide, obviously, how we can most effectively do that in writing and or orally. Anything else at this stage? Is there anything else anybody at the bar would like to raise with us?
Thank you. An email is coming in relation to restraining orders.
Thank you very much.
In respect of child Y, my learned union, Miss Sheffy, is going to be travelling to Southampton to attend him tomorrow.
Well, that's a good plan. Thank you for letting me know, Mr. Henry.
Would it assist my lady to know about an email that was sent to the Attorney General's office about the press?
Yes, I would like to see that.
One was sent on the 28th of May.
And it was addressed to who?
It was addressed to, for the urgent attention of Lord Hermer, His Majesty's Attorney General, please forward or bring to the attention of his PPS. I don't believe evidence, but one was sent.
Well, Mr. Little, do you have any objection to us seeing that letter?
No.
And if there's anything in response to it, then please, you are unaware of any response to it.
I never received a response.
Was it from you personally, Mr. Henry? Well, you can verify that, Mr. Little, one way or the other. Yes.
Apologies. On that subject, I wrote to the prosecuting counsel on the 27th of May, copying the royal counsel and expressing my concerns.
And you wrote to Mr. Sorry, who did you write to?
All prosecuting counsel, Mr. Tell, King's counsel, and Mr. Costa, who's junior for the Crown, copying in all my learned friends.
And I believe Mr. De Costa is attending remotely. She can hear you. Did you receive any response?
I did not receive any official response, but I've had conversations with Mr. Costa about this. I don't know if I'm betraying that confidence.
Or why don't you talk to her and see what we can be told? Very good. Well, thank you all very much indeed. I'm sorry that it's been very warm in here, hasn't it? So, well, it certainly is up here. I hope you've all been all right. Thank you very much to the court staff, and 2 o'clock tomorrow, unless you hear to the contrary.
All right, if able, have anything further to do before my lords and ladies, the King's Justice may now depart. God save the King, and my ladies and lords, the King's Justices.